Almighty God, by whom alone kings reign and princes decree justice, and from whom alone cometh all counsel, wisdom, and understanding, we, thine unworthy servants here gathered together in thy name, do most humbly beseech thee to send down thy heavenly wisdom from above, to direct and guide us in all our consultations, and grant that we, having thy fair always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace, and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
This meeting of the Honorable Senate for Friday, June 11th, 2021 is called to order. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following. Ministry Papers number 33 to 37 of 2021, entitled Cabinet Agenda Issues, dated March 1, 8, 15, 17, 22, and 29 of 2021. Annual report of the Petrojam Limited for the year 2019-2020. Annual report of the Company's Office of Jamaica for the year 2015-2016. Annual report on audited financial statements of the Real Estate Board and the Commission of Strata Corporations for the year 2017-2018. The Auditor General's Department analysis of the financial statements of the Universal Service Fund. And the Integrity Commission Special Report of Investigation concerning the circumstances surrounding the grant and the use of prescribed licenses and permits issued in relation to the construction and renovation of the Blue Diamond Hotel Group's Royalton Negril Resort. Also circulated for your information is a copy of the report of the Joint Select Committee on its deliberations on the bill shortly entitled the Sexual Harassment Act 2020.
Thank you, Madam Clerk. Bills brought from the Honorable House of Representatives, petitions, papers, reports from committees, notices of motions given orally, questions and answers to questions, motions that may be made at the commencement of public business requiring notice, motions relating to the sitting of the Senate, motions for leave to introduce bills, the presentation of bills without the leave of the Senate first obtained, public business. Madam Minister.
Thank you, Mr. President. Mr. President, it is intended today to take two important bills, the first being the Act to amend the Trademarks Act, and the other being the act more popularly known as the amendments to the Anti-Crime Act. I will be taking the first, and Senator Samuda will be taking the second.
And you are taking which first?
Trademarks.
Trademark.
Mr. President, thank you. Mr. President, Jamaicans are a creative and talented people. We're special in so many ways. Every country that you speak to, they say, of course, that their people are special, but we know that Jamaicans actually are. And we're special in so many ways. I mean, we're coming to this chamber at a time where we're all still on a high from Shelley and Fraser Price's blistering run, Khadija Bonishaw's golden boot in the French League, Brianna Williams' successes in her 2 events, and just the other day, Omar McLeod's world-leading time. And all of these are post-pandemic performances, so we are an incredible people. In addition to drawing record numbers of visitors to our shores annually, our rich heritage and culture, they're increasingly being harnessed locally and internationally, both for enjoyment and economic benefit. We're also proud of our icons, our legends, our brands, Bob Marley, Miss Lou, Usain Bolt, Blue Mountain Coffee, Jamaican Jerk. And these are all elements of us as a people that help to tell our story across time and geographical spaces. We also have incredibly talented, mechanically talented people. The transformations made to hand carts, solar water purification systems, oxygen-based harbor cleaning machines, fuel substitutes. We have seen the incredible things that have been developed by young Jamaicans in pockets across our beautiful island. The government of Jamaica believes firmly that our brands and our knowledge-based assets can be better leveraged for both individual and national development. And these IP rights, these intellectual property rights, must therefore be protected as best as we can and as broadly as we are able to do. Members of the Senate would be aware that Jamaica's intellectual property framework offers 3 major types of protection, namely copyrights, which protect literary and artistic works, give the owner of the works exclusive rights for their use, distribution, and sale, patents, which protect inventions and give the inventor the right to bar anyone from recreating, using, or selling his or her invention, and of course trademarks, which protect original designs, signs, and expressions that distinguish a product, service, or brand. According to the Intellectual Property Rights Index 2020, Jamaica's IP protection regime ranks 4th in Latin America and the Caribbean. 4th in Latin America and the Caribbean. And this positive ranking reflects our commitment to shaping a national intellectual property system that benefits first and foremost the interests of the people of Jamaica and supports the growth of Jamaica's knowledge-based industries. Most recently, the Parliament has approved the Protection of Geographical Indications Amendments Act 2018, as well as the Patents and Designs Act 2020, which repealed the Patents Act of 1857 and the Design Act of 1937, to introduce modern standards and safeguards for our inventors and to promote creativity. Before us today is the Trademarks Amendment Act 2021, and this bill represents yet another opportunity to strengthen our intellectual property protection framework by providing for Jamaica's participation in the system of international registration, protection, and management of trademarks. In 2013, Mr. President, as far back as 2013, Cabinet had given approval for the issuance of drafting instructions to the CPC for amendments to be made to the Trademarks Act and rules. And following extensive consultations and further work with a wide range of stakeholders, this bill before us today was passed in the other place on June 1st, 2021. The Trademarks Act 1999, which was further amended in 2013, is being amended to incorporate certain provisions necessary to implement the Madrid Protocol, which is formally known as a protocol related to the Madrid Agreement concerning the international registration of marks. Jamaica will therefore be able to accede to the protocol, making us party to the Madrid system of international registration of trademarks, a system to which 124 countries are party, with 108 members because of how those countries come together, responsible for 80% of global trade. 80% of global trade. Mr. President, this system, the Madrid system, has two primary objectives. One, facilitating the obtaining of protection for trademarks, and two, the more efficient management of trademarks and service marks by the owners of the marks and their agents. Acceding to the Madrid Protocol will allow for three improvements to our framework. One, a centralized filing procedure for international registration of marks through the JIPO in the English language, and JIPO is, of course, the Jamaica Intellectual Property Office. Two, one set of applicable rules for the international registration of marks. And three, fees being paid in one currency, including one set of administrative fees paid to the World Intellectual Property Organization, WIPO. So Jamaica's accession to the Madrid Protocol will result in Jamaica being able to be designated for international registration of marks under that system as well. And this will be beneficial to Jamaica as it will, among other things, simplify the application process for marks and improve access in global recognition and adjudication. In practical terms, accession to the protocol will mean that a Jamaican applicant, in practical terms for us here, a Jamaican applicant may file one application in English with JIPO and thereafter pay a fee to JIPO to obtain an international registration that would be effective in the territory of all state parties to the Madrid Protocol as selected by the trademark owner. Likewise, non-nationals and Jamaicans overseas may file an application in their country of domicile and, on paying the prescribed fee, designate Jamaica as one of the countries in which their said registration would be effective. So the bill undoubtedly will enhance Jamaica's competitiveness in regional and international trade by allowing for greater efficiency in the registration of trademarks in multiple jurisdictions, in addition to improving the ease of doing business for Jamaicans both locally and overseas, and increasing Jamaica's attractiveness as a global business hub. Accession to the protocol will open new pathways for income for trademark professionals in Jamaica. Ultimately, the amendments to the Trademark Act before us today represent yet another step in Jamaica's efforts to create the legal framework necessary to position ourselves, our country, as a competitive global business location. So the key amendments that will be put forward in this as a result of the bill before us today will be the local administration of the international registration of a trademark, setting out criteria for the international registration of a trademark, the application procedure of international registration of trademarks, making provision for the opposition procedure for the international registration of a trademark, and administration of fees in respect of the international registration of trademarks. So, Mr. President, in that context, I wish to now highlight the main elements of the bill through the clause-by-clause examination. Clause 2 amends Section 2, which is the interpretation section of the Act. And it's now being provided with key terms, key definitions to align the Act with the requirements of the Madrid Protocol, such as basic application, basic registration, contracting party designation, international register, international bureau, and such the like. Clause 3 amends Section 9, which seeks to allow equal protection for trademarks used for identical or similar goods or services and trademarks used for dissimilar goods or services. Clause 4 amends Section 11 of the Act to add an additional absolute ground of refusal of registration of a trademark where the trademark misrepresents or misappropriates the traditional knowledge or traditional cultural expressions of indigenous or local communities. So we can see that this is particularly important for Jamaica, as it undoubtedly would be for other small economies with strong indigenous cultures. Clause 5 seeks to amend Section 12 of the Act in order to expand the scope of protection of our country name and symbols. So now there is protection for the coat of arms and certain national, the flag and certain national symbols. But what this will add is also protection on the creation of a new 12(1) big A, is that the name Jamaica or the name of another country or abbreviations or homonyms thereof, a map of Jamaica or the national colors of Jamaica, a map of another country or its national colors, or a national emblem or symbol of Jamaica or national emblem or symbol of another country, that these must not be registered in Jamaica unless, or rather under this system, and the registrar may impose a condition or limitation on the trademark in the register to the effect, and this is the most important part, that goods or services for which the trademark is registered shall originate in Jamaica or in another country, as the case may be. So we have all been speaking for years about how upsetting it is to see, Jamaica black castor oil hair products where neither the bottle, the oil, or the label has touched Jamaican soil. We see it with other products as well, and this is intended to ensure that our name is more effectively protected. It's very important for us. And it is intended to ensure that within the system, that goods and services originating from the country, including Jamaica, named in the trademark, have a genuine connection to the country named in the trademark. And this is very important for us because we know how attractive brand Jamaica is. So its protection under this legislation is critical. Clause 6 amends Section 14 to correct just a reference error in relation to paragraph B instead of paragraph A. Clause 7 amends Section 22, which replaces the reference to a trademarks journal with the intellectual property journal. And this is to allow JIPO to maintain one intellectual property journal for all IP publications instead of having to maintain one for trademarks, one for patents, and one for designs and geographical indications. So this is about efficiency and cohesion in the administration of our intellectual property registrations. Mr. President, Clause 8 inserts two new parts in the bill. It inserts Part 3A, which will introduce sections 26 big A to 26 big D, and it introduces Part 3B, which will insert sections 26 big E to 26 big O, respectively. To deal first with Part 3 big A. This deals with international applications in respect of which Jamaica is a country of origin, so applications made here for outgoing registrations. And Part 3 addresses applications in which Jamaica is a designated country, so applications which will be made elsewhere, which will be recognized here in Jamaica. So 26A outlines the circumstances in which an international trademark application under the Madrid Protocol may be filed with the registrar by persons who are either nationals of Jamaica or domiciled in Jamaica, or who have a real and effective industrial or commercial establishment in Jamaica. The section also outlines a procedure to be followed where the registrar receives a properly filed international trademark application under the Madrid Protocol. 26B provides that all communications, including the international applications to the International Bureau, shall be in English and be transmitted through the registrar. And this is quite a good simplification for Jamaica navigating international territory. 26C provides that the international trademark applicants may request that their international trademark application be extended by the International Bureau to other territories not originally included in the application. And 26D provides that an international registration of a mark shall be valid for 10 years from the date of registration, and also that on the expiry of the 5 years from the date of registration, the international registration shall become independent of the basic application or national registration. So this section further provides that the protection resulting from an international registration may not be invoked if within that 5-year period the basic application or national registration is cancelled, invalidated, or revoked. So going now into Part 3B, which as I indicated before is about international registrations in which Jamaica is designated. So we are chosen as a country in which the mark should be protected as well. 26E specifies that the registrar shall publish the international registration in the Intellectual Property Journal and proceed to examine the international registration on substantive legal grounds only. So under the Madrid Protocol, the International Bureau examines the applications for formalities and priority claims. And the intention under the protocol is that in every country, they don't go through the formalities and priority claims again. It must be that the national office only looks at the substantive legal grounds for registration so that we are not duplicating and overly extending processes. The section also provides that persons may oppose international registrations coming into Jamaica by filing with the registrar a notice of opposition within 2 months from the date of publication. And publication in this instance takes place on the JIPA website, which they do regularly at a particular time and is always available to public, mostly, of course, checked by lawyers, but it is there on the JIPA website. 26F specifies that the registrar shall notify the International Bureau of the refusal to register any international registration within 18 months of notification of registration by the International Bureau, along with a statement of the grounds of refusal. And 26G provides that when all the procedures before the registrar are completed and provisional refusal has been either totally or partially withdrawn, the registrar shall send notification to the International Bureau to that effect. 26H provides that when all procedures before the registrar are completed and the registrar has decided to confirm a provisional refusal, the registrar shall send the notification also to the International Bureau to that effect. 26I provides that when all procedures before the registrar are completed and there is no ground for the registrar to refuse protection, then the registrar shall within 18 months send to the International Bureau a statement to the effect that protection is granted to the mark. And 26J provides that if after the registrar has notified the International Bureau that protection is granted or refused for the mark, there is a further decision which affects the protection of a mark, the registrar shall send to the International Bureau a further statement indicating the goods and services for which the mark is protected. New Section 26K clarifies that an international registration designating Jamaica will have the same effect as if the application for the registration of the mark had been a national application filed directly with the registrar and the mark had been registered directly by the registrar. It also stipulates that the filing date of the international registration is the date of the international registration or subsequent designation. 26L prescribes that where an international registration designating Jamaica is cancelled by the International Bureau, the person who was the holder of the international registration may file an application for the registration of the same trademark directly with the registrar as a national application. And 26M permits international registrations designating Jamaica to be renewed for a period of 10 years from the date of expiry of the international registration. And the application to renew an international registration must be filed directly with the International Bureau. 26N requires that if an international registration designating Jamaica is a collective mark or a certification mark, it must comply with the provisions of the first and second schedules of the Trademarks Act. And 26O stipulates that where a mark that is the subject of a national registration in Jamaica is also the subject of an international registration, and both registrations are in the name of the same person, the international registration shall be deemed to replace the national registration subject to certain specified conditions. The holder of the international registration may request the registrar to take note of that international registration in the trademarks register. So, of course, the subtext of all of that is the recognition that what exists now, our national registration process, will continue to subsist. The Madrid Protocol will provide an additional, an alternate process for registration of trademarks, and one which clearly has a broader international recognition than the national registration. But both will continue to exist in Jamaica. This addition of the ability to accede to the Madrid Protocol does not in any way inhibit or constrain use of what exists now in terms of Jamaica's trademark registration processes. So Clause 9 inserts a new Clause 55A in respect of preliminary searches and advice, which allows the registrar to give advice as to the registrability of a mark prior to application. And Clauses 10 and 11 amend Sections 58 and 59 to replace in both instances references to JIPO with the word office, which is now defined in Section 2. Clause 12 will amend Section 60 to clarify that any appeal that may be filed under the Act against the decision of the registrar must be filed within 28 days after the date of the decision, and that any decision, judgment, or order of the court on appeal concerning an international registration shall be communicated to the International Bureau by the registrar. Mr. President, Clause 13 provides for the insertion of new sections 61 big A, 61 big B, and 61 big C. These, Mr. President, deal with the following matters: the effect of recordings in the International Register, wherein new 61A provides that subject to 61B, C, and 62A, any recording made in the International Register in respect of an international registration, to the extent that it applies to Jamaica as a designated contracting party, shall have the same effect as if it had been recorded by the registrar in the Register of Trademarks at JIPO. 61B deals with change in ownership of an international registration, and it provides that the registrar may declare that a change in ownership of an international registration has no effect in Jamaica. And this may arise, for example, where the same international trademark owner has national registrations in Jamaica as well, but has not made the same request to change the ownership of the national trademark registration here. So the ownership here would still subsist. And the fact is, however, that the registrar, in making such declaration, must provide the reasons and the legal basis for such declaration, and the holder of the international registration may request a review by the registrar within 28 days. In respect of 61C, the registrar may declare that a limitation of goods and services in an international registration has no effect in Jamaica, and the registrar must provide the reasons and legal basis, and the holder, again, of the international registration may request a review by the registrar in 28 days. Clause 14 inserts Clause 62A, or Section 62A, which deals with correction of the international registrar. So the registrar here may declare in a notification of refusal to the International Bureau that protection can no longer continue to be granted to the international registration as corrected. From time to time, WIPO will issue corrections to mistakes made either by itself or by the Office of Origin, and in such instance, we will be able to refuse the mark if we can no longer grant protection due to the correction which has been made internationally. The registrar must provide the reasons and the legal basis, and the holder of the international registration may request a review by the registrar within 28 days. Now, these last three clauses which I have referred to, the broad process, what is interesting to note about them is that it's required, it's set out in the provisions, that where there is an objection or where there is a limitation or a change in ownership, that these matters must be dealt with through a local agent. So the person must be domiciled in Jamaica, must be able to be served with a notice in Jamaica, and therefore this is part of the arena in which we will have new professionals, there's scope for development of employment as trademark agents, so that it is, while these matters are only dealt with generally by attorneys now, there is this broader recognition that exists here as it does in other countries and provides for their scope for development of a new area of employment and professional qualification. Mr. President, Clause 15 amends Section 78, again by simply referring to the word office instead of JIPO. And Clause 16 amends the third schedule by deleting a list of paragraphs which are no longer applicable. And essentially, they are no longer applicable because the third schedule was originally included in the 1999 Act as a schedule of transitional provisions from the 1958 Act to deal with pending applications at that time. As there are no such pending applications anymore, all of these paragraphs are no longer applicable, and they are therefore being deleted. Mr. President, I close simply noting that Jamaica's wealth of creative and knowledge-based talent can indeed more effectively be harnessed for personal wealth, for individual wealth, as well as national wealth creation through more effective use of intellectual property rights. The government will continue to work to provide the framework that prevents appropriation of our cultural and knowledge-based assets while nurturing fledgling assets. The work has been done to assess JIPO's ability to treat with the administrative sides of this new bill and has been assessed by WIPO and found to be not only compliant with all the requirements, but certainly more than able to manage the requirements as required by every national office that accedes to the Madrid Protocol. And it is in this context that I proudly commend the Trademarks Amendment Act 2021 for the Senate's consideration and approval. I thank you.
Thank you, Minister. Senator Scott Motley.
Thank you very much, Mr. President. I rise to make some brief remarks in relation to this bill which is before us today. I embrace the examples of the prowess of Jamaica which was given by the leader. There is a term which is used very widely, that we little but we tallow. And Jamaica has long established that it is at the forefront of many developments and many achievements internationally. Mr. President, I'm sure that you have traveled and seen on the menus Jamaican jerk chicken. I'm sure that you have gone into the stores and seen Jamaican coconut water or Jamaica ginger beer or Jamaica ginger ale. And this is because Jamaica, the name Jamaica, the brand Jamaica, has so much cachet that persons are actually using it in order to cash in on 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 the significant earnings which you can make from using that. Of course, there are legitimate users of the brand Jamaica, some of them with whom we are very familiar, and we acknowledge the efforts that they have made to promote Jamaica overseas. But, Mr. President, it is sometimes very harmful, especially when we have a brand such as our Blue Mountain coffee, which everyone knows when it is the real Blue Mountain coffee. Not only is it a pleasure for coffee drinkers, but the aroma, just the aroma alone, can awaken the senses. So I say that there is no doubt about the fact that Jamaica is at the forefront of so many things and unique in so many different ways. This bill will attract some attention from the populace now, because you'll recall that in 2019, when we had a visit by Kanye West, some sort of concern in some quarters, and I use the word euphemistically because it generated anger in certain areas. Some sort of concern was raised when Kanye West began to sell items, memorabilia, using the Jamaican coat of arms. And that is when Jamaica kind of stood up and said, what? How can this be permitted? That somebody from outside could come and use our emblems, just appropriate to himself the right to use an emblem in this way. And there were suggestions that every cent that he made should be given back to Jamaica. There were suggestions that he ought to be sanctioned for having done this. And Dreypo did point out to us at the time, though, that immediately that he was notified that he could not, he took everything down and discontinued with his sales. I enjoyed the discourse around it, because anything that makes our Jamaicans more aware of things like this, and it's usually something controversial, I think it is a good thing to have this discussion. So we come today to this act, which will allow us to be part of the Madrid Protocol. There are other Caribbean countries which are already part of the protocol. And it was surprising to me to see that Cuba was one of the first countries to sign on to what was protocol agreement and so on. There is a way in which this is certainly going to enhance Jamaica's international reputation as a place for doing business, because the multiple layers of registering your trademark will be now alleviated. And so you can register in one country and it will be recognized amongst the 108, if you want to call it that, or 124 countries who are already signatories. It is not quite as seamless as that, though, Mr. President, not quite as seamless as just a registration here and it is just accepted. Because indeed and in fact, each individual country has to give some sort of approval for the registration, so that there might also arise in a particular country an objection to a trademark. So it doesn't come just smoothly, it's not just without any kind of consequences or any kind of hitches or anything happening in that regard. But I must admit that along with our Patent and Designs Act, which we passed here recently, it does make, and I think it was the Apostille, is that leader, the Apostille Act that we did. We see where we are moving towards reducing the bureaucracy that we encounter when we want to get things done and when we want the international recognition for the things that we do. I did not agree, though, and I think the attorneys who practice at the bar and who are specialists in this area do not believe that it will enhance them professionally. And I do not believe that the fact that there is reference to a duly appointed agent domiciled in Jamaica together with a power of attorney does add a sense of clarity to the role of the attorneys at law. And let me tell you why I say so. Let us look at Antigua. Antigua has been a member of this protocol for a very long time. But what Antigua did was that it created a special provision at Section 18 of their Trademarks Act. It makes a provision that where an applicant's ordinary residence or principal place of business is outside Antigua and Barbuda, he shall be represented by a registered agent resident and practicing in Antigua and Barbuda before the registrar of the Intellectual Property Office, and goes on to say that the procedure for the registration of an agent shall be prescribed in the regulations. Now, the regulations actually makes it very clear that the definition of a registered agent is an attorney at law. I have to say that the practitioners in this area are a very, very small group of practitioners, and they are excellent. In very much the same way that JIPO has demonstrated over the years that this is an organization which is deserving of being lauded internationally for its efficiency. It's the same way that our attorneys who practice in this area are internationally recognized. As someone who sits on the accreditation committee of the General Legal Counsel, I can assure everyone that they're very diligent in pursuing all the courses available and going to all the annual conferences so they continue to hone their skills in this area. When we were discussing the Patent and Designs Act, I did raise my concerns on that occasion, and there was an assurance which was given that at some point some amendments would be made, and it would be the act would be brought back for some kind of review as we saw how things unfurled. I think we are presented with an opportunity to make the role of the attorney at law in this Trademarks Act pellucid, so that there's no need to wonder whether or not they fit within the definition. And I would urge that the definition, that a look be taken at the section in the Antigua and Barbuda Trademarks Act and see if there's no way in which we could incorporate this with this kind of precise language. I also, Mr. President, wish to raise a particular concern about one of the proposed amendments. At Clause 4, which purports to amend Section 11 of the Principal Act, there is an insertion which prevents one from misrepresenting, misappropriating the traditional knowledge or traditional cultural expressions of indigenous or local communities. I was concerned by exactly what it was that was being designated. What is being deemed traditional knowledge? What is being deemed traditional cultural expression of an indigenous or local community? Which communities are considered indigenous, for example? And I think there has to be some kind of clarity in the legislation. Are we talking about, for example, the Maroons? Are we talking about the practices used there? If you were to consider the place where I grew up, Mount Providence, and the way sometimes that they speak, is that something that you are protecting? Is it the way that some people pronounce in St. Elizabeth, words in St. Elizabeth? I mean, you can't just have it as broad and as wide as that without any guidance as to exactly what is being prohibited in Jamaica. That is my view. I will confine my words to those things that I know about. And I'm not an expert on Robin Mango. So seriously, Mr. President, I would like a look to be taken at that. You see, one of the reasons why we pass the legislation is that we have to add clarity to our situation. And I would love to hear how this particular clause was being contemplated. In closing, Mr. President, I acknowledge the fact that there is protection being given to the use of our symbols. I acknowledge the fact, and I actually quote from one author who pointed out that unique historical, social, and cultural identity that comprise the ideas of nationhood and nationality are very, very important for protection. I endorse the view that there is a possibility that this legislation will open up prospects for persons beginning to specialize in this area. And especially when you have so many people graduating from law school, I hope that some mentoring will be done to guide them into these niche areas, to be able to develop this particular kind of expertise which would serve us so well. I look at a downside of the legislation, however, and as I prepared myself for an understanding of what this was going to, the effect of the Trademark Act, I realized that Jamaica had some kind of advantage under this legislation because it was usually used for stealth filing, or in some what they call submarine filing. And what that means is that big companies who would want to register a trademark that might signal to their competitors what they were about, if they did it internationally, or if they did it in certain jurisdictions, would choose places where persons did not have it, which persons did not have as much on their radar, like Jamaica, and would register it here in Jamaica. So in other words, they cordon it off in much the same way that somebody would register a domain name, because, say, Cavan Gale, because they know that he's famous and he's going to need to have his domain name a little later. What they would do is actually park it in Jamaica until the time would come when they would use it. I also wonder how exactly financially it will benefit us. Because in the past, when you had to register in each separate country, then the administrative fees and so on would accrue to that country. But now that you can do it, the international companies can do it in the place of their domicile. How does that affect Jamaica in terms of the income it can earn in this particular area? I would want to get an indication of that, if it has a negative effect. I do understand, Mr. President, that in terms of putting Jamaica in the category of those, being a place where it is easy to do business, that is a clear advantage. But there are other aspects that we must analyze before we embark on a process. Trinidad actually became a member of this protocol in January 2021. And speaking to my colleagues from that jurisdiction, I gather that their income is already reduced. The income which is earned from the registration is already reduced because the international companies who they would normally represent in Trinidad are now opting to file elsewhere. And so I think that whatever we are going to do, we have to have an analysis of the benefits as against the losses. But in closing, Mr. President, I do say that I understand the path, and I do consider that it is necessary. I'm never pleased when I look at these protocols and see that there are other places in the Caribbean ahead of Jamaica, because I want Jamaica to be the leader in all things. And so I signal my own approval of this bill, if it pleases you.
Thank you, Senator Scott Motley. Senator Webby.
Thank you. Thank you very much, Mr. Thank you very much, Mr. President, and good morning to all of my colleagues in the Senate. Mr. President, I rise in support of the Trademarks Amendment Act 2021, and let me say that I want to congratulate our leader and Senator Scott Motley for what I thought was two excellent presentations. So thank you very much. I actually learned a lot about it. Mr. President, as you have heard before, the bill will pave the way for accession to the Madrid Protocol, an international treaty designed to simplify international trademark registration process. And let me say, as a businessman who is involved in international trading, I welcome this amendment with open arms. Let me also acknowledge the Honourable Minister Shaw for taking the leadership of the bill as the responsible minister, and his commitment to have the protocol ratified and implemented by July of this year. Chairman and colleagues, you always hear me say what gets measured gets done, Senator Brown. And I like when timelines are put in place, and Minister Shaw has committed that it will be done by July of this year. The truth is, like Senator Scott Motley and our leader, sometimes I ask myself, why has it taken so long? But it is here, and I'm pleased that we are finally doing it. Mr. President,
no, stay there.
When you look at the WIPO, the World Intellectual Property Organization, describes the Madrid system, which I like this definition, as a one-stop solution for trademark holders to protect intellectual property in multiple markets. And I think that captures the essence of what we are debating this morning. And currently, we have 1.3 million trademarks that are registered in the system in over, I think, 124 companies. Mr. President, I can relate to this amendment on a day-to-day basis, given my role as chairman of or CEO of Grace Kennedy and as a private sector leader. So I can really appreciate the immediate benefits to Jamaica and the Jamaican private sector of using the Madrid system. And I give you a practical example, Mr. Chairman. At Grace Kennedy, for example, we have 235 registrations which are managed in over 130 countries. So you can imagine the cost, the bureaucracy and administration involved in such an exercise. So with this one-stop solution, these costs will be significantly reduced and the overall monitoring mechanism will be simplified. You know, in preparing Senator Scott Motley and my colleague lawyers in the House, Senator Fraser Binns, I often try and ensure that there's some amount of alignment in my thoughts. So I asked a number of my colleagues in the private sector and others in academia, what is your understanding of intellectual property? And I got so many different angles and definitions of what intellectual property is, or the meaning or the definition. So I said, you know, Senator Gill, I said to myself, let me go and look it up, just to ensure that I'm aligned in my own thoughts. And it actually resonated with me that this is so wide that there are going to be opportunities there. So I'll share with the Honourable Senate this morning. It says international property IP is often used in the business world, but to ensure full alignment, as I said, what it means, it speaks about the creation of the mind, the creations of the mind, literary and artistic works, design and symbols, names and images used in commerce. Let me just say it again. IP refers to the creations of the mind, literary and artistic works, design and symbols, names and images used in commerce. And you know, I said to myself that we in Jamaica, such a great country, we must find a way to monetize IP for the benefit of all Jamaicans. So our accession to the Madrid Protocol and the changes in the bill that we are debating this morning will provide benefits to multiple sectors in the Jamaican economy. Manufacturing and export will benefit, agriculture will benefit, tourism will benefit, the creative industries, Senator Allen, must benefit, the musicians, the songwriters, to name a few. So what I'm seeing here is a significant amount of opportunities, having aligned ourselves in terms of what does IP really mean. So having said that, Mr. President and colleagues, the bill actually represents a huge step forward for our country. It supports and encourages the development of Jamaican talent and authentic local products, reduces the costs associated with protecting against brand exploitation, which was mentioned by both speakers, and provides increased access to new markets and speed to market for businesses. So in essence, instead of multiple applications for registration and various fees, Jamaicans can now use a single application and pay one set of fees to register and protect their intellectual property rights. Mr. President, Jamaicans are creative, talented, and innovative. And we have to help our people to understand the value of their intellectual property and how to protect it. Mr. President, we often pass legislation and is not supported by a significant education campaign. So the little man at the corner of North and Duke Street that is, as we say, busting a tune, he can benefit from this amendment in terms of registration. the gentleman that is on the Ocherius market creating a new product, he can benefit from it. So this is not about the big companies. This is about educating all the creative minds in Jamaica to benefit from this amendment. It is wide. So I'm saying that with the amendment of this act, we need to collaborate to provide education and sensitization programs about the importance of trademark registration and the benefits to be derived from Jamaica's accession to the protocol. I certainly see this legislative change as a huge, huge positive for the small and medium-sized business sector, once properly educated. I also want to support what Senator Johnson Smith said about JIPO, and I think, when we have an entity in Jamaica that is doing a good job, agency, we need to recognize them. And it's no mean that based on WIPO's assessment, they are saying that our JIPO is doing a good job. And I really want to congratulate them wholeheartedly in terms of being world-class in our Jamaican scheme of things. So congratulations, JIPO, and continue to do the good work that you are doing. Mr. President, I'm going to wrap up with something that I'm very, very passionate about, and as chairman of JAMPRO, we have been discussing it quite a bit, and in fact, we have done a number of presentations. It's about brand Jamaica. It's about brand Jamaica, and as somebody said earlier, we little but we Talawa. Anywhere in the world that you go, there's some feel, some sign, some presence of Jamaica. I mean, if you go to gate D29 in the Miami airport, speaking a little bit selfishly, there's a lovely Caribbean restaurant there with all the branding of Jamaica. You go to the Tube in London, there's Usain Bolt in his Jamaican outfit, and as we said, Shelly Ann and Bob Marley is everywhere in the world. I went to a small village on vacation with my family called Interlaken, and there was a reggae bar, restaurant and bar with Bob Marley all over it. Who would think I would see a Jamaican there? So, the truth is, colleagues, we have a rich culture. As I said when I speak, Jamaica is the greatest country in the world. We have a rich culture. We have our problems, but at the end of the day, we are the greatest country in the world. We have a rich culture, heritage, and a legacy as a country which others have recognized. Others have recognized. And I'm going to try and to be diplomatic, because I can tell you, I feel it every day. And in some cases, have sought to capitalize on our gain. I have received over the years, the many, many years, numerous emails and messages from persons in the diaspora. And Senator Johnson Smith, I consider them ambassadors for Jamaica, because anything goes wrong, they are with me. Speaking about products that have no relations to Jamaica, but are claiming to be produced and manufactured in Jamaica, which is really sad. The company that I represent, we have 6 manufacturing plants exporting 30 to 40% of that, and it's almost like unfair competition where they're exploiting the Jamaican brand. And I think that this will strengthen that in terms of protecting our Jamaican brand. I noted the amendments to, I think it's Section 12 of the legislation, which mandates the permission of government is required to use national symbols and emblems in a trademark. And I think that's a move absolutely in the right direction. Section 12 also states that the registrar may impose a restriction or limitation that goods or services must originate in Jamaica if their trademark includes national colors, the name and map of Jamaica, or the national emblems and symbols. That is a very, very positive move for us. This is certainly a step in the right direction to protect brand Jamaica. I acknowledge that work has been done to date in terms of the geographical indications which allow producers and manufacturers to benefit from the characteristics and reputation of products which are derived from the geographical area or region where they are grown or produced. I acknowledge the work done in the GI, such as Jamaica jerk, which is a growing market. I can tell you that jerk market is growing probably at about 40% per annum for the last 5 years worldwide, and Jamaica rum. So I support wholeheartedly the expansion of GIs to drive growth in the production and manufacturing sector. So in closing, colleagues, Mr. President, as you see, I'm very passionate about this. I think it's a potential game changer, not only for the large companies in Jamaica, but for that musician on the street corner or that creative person in the market of Ocherius. So I again offer my support for the Trademarks Amendment Act 2021 for the reasons I mentioned earlier. Mr. President, I thank you very much.
Thank you very much, Senator Webby.
Mr. President.
Senator Fraser, for Fraser Beans.
Thank you, Mr. President. Thank you, Mr. President. I stand to make my very brief, Senator Gale, very brief contribution. Senator Gale and I had a little discussion this morning. No, but it's in fact very brief. My very brief contribution to this debate, the bill to amend the Trademarks Act. Senator Webley, you know, and I think I'm beginning to sound like a scratch record, but every time I stand to speak on anything to do with the creative industries, I always mention Vanessa James. And for those of us who practice in the creative industry, or shall I say, who used to practice in the creative industry, then we must know who Vanessa James is. And Mr. James, in his book, spoke about the impact of the creative industries on the economy of Jamaica. And he mentioned that if you invest $1 US, and I'm paraphrasing now, but if you invest $1 US in the creative industry compared to other industries, then what happens is that you multiply that effect 5 times. And so when I heard you talking about the entertainers and the different practitioners within the creative industries, I am heartened because it is quite true that the creative industries really stand out among the contributors, or the very likely contributors to the GDP. The fact is that it has taken us so many years, so many decades, in fact, to have an appreciation for the real impact of the creative industries. And we have been seeing some signs. I know we had the Copyright Act earlier, and we did the Patent Act, the Trademark. I know we're amending the Trademark Act to give effect to our own agreement under the Madrid Protocol. And all of these are steps in the right direction, and I can only hope that we continue there. But the fact remains, though, that there remains so much more that must be done for us to take full advantage of the creative industries. And it goes beyond just patent and trademark. If we go to perhaps, and I see the legal officer from the ministry here, and it goes beyond, if we look, for example, at perhaps the widest participants in the creative industries, who would be our entertainers and persons involved in the everyday copyright system, what is clearly lacking is a harmonization, a coming together, but also the required professional engagement that is required for us to fully have, for us to fully exploit that industry. I remember back in the days when I was much younger and thinner, I did a paper looking at the contribution of the, looking at how laws impact the contribution of the creative industries in Jamaica. And one of the things that stood out for me was the Copyright Act, which was quite new, and the whole issue of piracy. And even though we have this act, and we talk so much about piracy, we had all these ads on the media, you find that there was still a significant number of Jamaicans who were involved in burning CDs and burning DVDs. And that has not changed much, notwithstanding the cases that have gone to halfway through. It still hasn't changed. And, you know, depending on where you do your shopping or you do your other activities, it is not unusual for somebody to just come to you and say, you want a DVD for buy? And I'm like, do you know that it's legal, right? But the fact is that there's still so much to be done. But notwithstanding all those challenges, today is a good day for persons involved in the persons involved in the creative industries. And it is a good day because it is a step towards the right direction in terms of our quest for harmonization of what we do, and in particular in terms of the Trademark Act. You see, Mr. President, the fact is that we cannot operate in silos. Senator Webby spoke about his own experience being the chairman and CEO of an international company. And the reality, Senator Webby, is that the world has gotten smaller and smaller, and borders as we knew it have been eroded and have gotten less and less. COVID, in fact, is one of the things that have confirmed that international borders as we knew it then no longer exist. What has given rise is international trade. E-commerce is on the rise. And so matters of patent, matters of copyright, matters of trademark are becoming more and more important. And I agree with you that apart from passing modern and relevant legislation, as a country, we are going to have to find a way to educate, to inform, and to get compliance amongst our populace on these very important matters. And I want to also give support to you that while we pass this amendment, these amendments today, that we also commit, and I ask the government to commit to a new and inventive public education campaign that will allow everyone to understand and to comply. Because some people understand, but they don't comply. And I'm hoping that as we continue, we will have a greater compliance rate. So, Senator Webby, you spoke about the importance of these amendments and the economic benefits, which, again, I am in full agreement with you that can derive. Because, indeed, what it does is it reduces the financial burden on companies who no longer have to have a trademark in Jamaica, a trademark in the Caribbean islands, a trademark in the US, or a trademark in Africa, not looking at anybody. It reduces that. So what happens is that you literally have a one-stop shop. But the other benefit of these amendments is the first file benefit that derives. In other words, if you, prior to now, if you file an application for trademark in Jamaica, and it is accepted and registered, then that protection is in Jamaica. If someone in Africa, for example, wants to use that particular trademark, there was no guarantee that the trademark you have in Jamaica would extend there. What the first filing does, or what the amendment does rather, is that it gives you that benefit of first file. So once you file in Jamaica, you don't have to rush to file in Africa. And if somebody in Africa, for example, seeks to file, or if there's a dispute rather about that same trademark in another country that is governed by the treaty, then the court will rely on the first filing to determine who really has the right. And I think that is a benefit that we must talk about. Mr. President, the bill is actually has my support, but I want to just highlight a few sections for consideration. And I know, I regrettably, Minister, I wasn't here to hear your opening, but I did hear what Senator Webb said about the amendment to Section 12 at Clause 5 in terms of the amendment as to who or the use of the national symbols. And the present bill, the present act, has an absolute provision that they can't be registered. I wanted to understand, Minister, the reason why we have now changed from that absolute provision to a qualified position. My personal view, I really like the absolute. I like the absolute, especially when it comes to our coat of arms. I can understand some need for a qualified position in terms of the Jamaican flag, but when it comes down to the coat of arms and other symbols, I have an absolute preference, which is my preference is that it should be absolute. But I shall like to find out, it should be absolute, as in you cannot register anything using the national symbol, particularly coat of. And I would really want to understand the reason why there's a move now for there to be a qualified use of it. And also, you know, who gives, in the operation of this, who gives the permission for it to be used? I note it says that it shall not be registered unless the registrar is satisfied that consent has been given by or on behalf of the government of Jamaica. But who really gives that permission? Is it going to be the Ministry of Culture? Is it going to be coming from the OPM? Is it going to be coming from industry? Is it going to be coming from, there's this body that deals with national symbols, and I can't recall that name right now. But who exactly will give this permission? And what heritage, yes. Is it going to be coming from there? Who gives this permission? And what are the considerations to which this body will address its mind in giving the permission? So that is something that I have a little unease with, and I would be so grateful to have further and better particulars about it. Continuing at 1A, that's 5.1a, where it talks about where a trademark, which is the subject of an application or registration, contains the name of Jamaica, a map of Jamaica, or a national album, the registrar may impose a condition or a limitation on the trademark in the register to the effect that the goods or service for which the trademark is registered shall originate in Jamaica or in another country, as the case may be. I have a problem with that, Minister. And I tell you why I have a problem with it. If it were that we were saying that the permission to use these other things would be given if the trademark is registered, if the trademark is registered or originates in Jamaica, then I could understand. But in another country, as the case may be, I have much discomfort. And I tell you why I have much discomfort. Some of which Senator Webby spoke about, clearly not in support of my point, but it is the exploitation that has taken place with our national symbols, with the things that are uniquely Jamaican. And I don't believe that we should encourage the use of the word Jamaica or Jamaican, or that we should encourage the use of our symbols for things that are not unique to Jamaica or things that have not originated from Jamaica. So, you know, for example, we know there's no doubt that marijuana is a big sell now. And there is also an international acceptance that Jamaica marijuana is the best. And I'm not speaking from experience, by the way, but there is an international acceptance that it is the best. that is the best. But think about this, Senator Hill. Senator Hill, think about this. That, you know, somebody, because they know, or even our Blue Mountain coffee, yeah? because they know the pull factor of the Jamaican weed or Jamaican Blue Mountain coffee, and they want to trademark it, they can easily just put Jamaica. It has nothing to do with Jamaica, not even the seed, whether it's the coffee bean or the ganja seed, did not come from Jamaica at minimum. So I see in a very clear way the real possibility of this being exploited, and I would want to state on record my own challenge in accepting that provision. I would be willing to accept if it were to stop at shall originate in Jamaica, but or in another country, as the case may be, I would have much challenge in accepting that. And so, Minister, I look forward to a response when you speak in the closing. At Clause 8, it really speaks to the operation and the procedure of the protocol in Jamaica and its incorporation. But Clause 26A, which is being amended, C, speaks to, it says an international application may be filed with the registrar where the owner of the national application or national registration is a national of Jamaica, is domiciled in Jamaica, or has a real and effective industrial or commercial establishment in Jamaica. I have some discomfort, and I seek some clarification on the words, or has a real and effective industrial or commercial establishment in Jamaica. I stand to be corrected, but I don't recall seeing such language in any other piece of legislation, and I stand to be corrected. I do know, for example, that when we're looking at the Procurement Act, and we're trying to carve out a special treatment regime for small businesses, which are not uniquely Jamaican in terms of registered in Jamaica, we looked at how we can ensure that there was a close relation to Jamaica, and it's very, very clear in terms of how you make that determination. But the words a real and effective industrial or commercial establishment in Jamaica, in my mind, is not very precise, it's not very clear, and it leaves the opportunity for it to be interpreted very broadly. And the challenge I have with that is, how does one measure this real and effective industrial or commercial relationship or establishment in Jamaica? Because if a company, for example, were to establish that, or were to say it has this kind of relationship in Jamaica, then if you're an international company, then maybe a subsidiary, or at least registering it as a overseas company operating in Jamaica, because those are very clear and practical ways in which you can cite that relationship, you can establish that relationship. And to that extent, I would want some clarification from the minister as to why it felt it necessary, and I know the technical team is here, to add these words, and how exactly do you determine or interpret if someone has a real and effective industrial or commercial establishment in Jamaica. Then we look at the issue of fees, and this is page 6, clause 2, 26A2. And it says that the application made under this section shall be in the form prescribed and accompanied by the prescribed fees. I have no challenge with that. The only thing I want to say is that in determining the fees, we have to, on the one hand, be very mindful that we do not set fees that will be a deterrent. I hear Senator Scott Motley in her presentation spoke about the negative financial impact it is having on our Caribbean colleagues who no longer have the bulk of work coming in. And so it is important that we set a fee that will not be deterrent. But at the same time, we must set a fee that allows for real income to come to the government, to JIPO. And I say that because one of the things that we must not be afraid of is to really levy where levy is to be done, particularly on international companies. In the US, for example, the US Patent and Trademark Office, Senator Braham, is one of the few government offices that have an income that can assist in the federal budget. And that is because they are not afraid to charge reasonable fees. I am told that just one part of the procedure for a patent application is $50,000 US. So I am hopeful that once we start working through the prescribed fees, that we will address our minds to all the consideration and in a very balanced way levy fees or charge a fee that will allow JIPA to be fully functional. And this is important, not only because it could assist the central government in terms of its budget, but also we spoke about the importance of public education. And JIPA is going to have to lead the way in public education. I mean, it has been doing a good job, but there is still so much to be done. And it can do more if it has its own funding, this can be a source of funding. And in addition to which, there are going to be, well, I don't know how JIPA envisions working through this, but I would surmise that certainly additional staff would be required to review and to examine these applications when they come in, to make sure that we are not just complying with the protocols, but that our own local laws are being complied, particularly those that are registered outside and Jamaica is designated. So it's very important. So we're going to need additional staff, and I believe that this could be a direct source from which we can have, we can engage such persons. The rest of the bill, for the most part, really is just harmonizing what presently exists. At Clause 26D, we talk about a 10-year, which is something that presently exists in our law. And I guess for harmonization, uniformity, we continue with that 10 years. I'm wrapping up, Senator. Oh, he's not in here, but I did promise him that I will not be too long. So I'm wrapping up shortly. At 61B, where it talks about the change in ownership, and I'm particularly delighted with the use of the word may as opposed to shall, and I'll read it. It says, where the registrar is notified by the International Bureau of a change in ownership of an international registration affecting Jamaica, the registrar may declare that the change in ownership shall have no effect in Jamaica. And I'm particularly delighted because what it does is that it gives the registrar freedom and flexibility to make such a declaration, and again, to own our laws, to ensure that whatever changes are being done outside of the jurisdiction, once it impacts Jamaica, that they are in compliance with our laws. And this is something that finds favor with me. As I close, Minister, I want to say that these amendments represent a step in the right direction for all the reasons said earlier. But we have to ensure that as we move now to operationalize, that we not only give credence and adherence to the Madrid Protocol and rules, but that we consider international practices. So one of the things I know that has been impacting some of the larger countries, and I can speak with some knowledge of what is happening with the US, is that you have bad actors. And these bad actors, they go in, and it's not unique to US, but they go in, they get information, there's scamming that's taken place, people are given notification about renewal, and all kind of stuff. So it is important for us that as we expand, because I foresee an expansion taking place, that as we expand, that the requisite security is put in place to ensure that not just persons' information are protected, but that we build the confidence that Jamaica is indeed a hub, but a hub where information is safe, information is secured, And I think if we do this, then what will happen is we will have more and more countries, more and more persons coming to us for registration. It will transfer into economic, ready for this word? Kevin is not here, but I know Minister Hale, you're going to like this word. When you have more persons coming on board, it's going to transfer into economic prosperity. Shall I say it again? I know. Apparently, I got permission to use it before I spoke. So, but seriously though, what will happen is that there really is a direct economic benefit that is going to result from this, and Jamaica can only stand to benefit. So not only will we be harmonizing our local laws with the best practice, with the Madrid protocols, but we will also be, we will be incorporating international best practices and best standards. And with the proper security, with public education and the correct management, then I believe that we will definitely be the go-to country. And this is easy to foresee because Jamaica is really rich in terms of our cultural heritage, in terms of our copyright, and I mean our creativity is unparalleled. So we do already have the foundation upon which to build, and our technical expertise. Again, I want to commend the work of JIPO. I have had several occasions to interact with them, and whereas I'm not looking at anyone, I just saw that my very dear friend is here as well, who I can pick up the phone and say, I have this IP matter, what do you think? And so, Dr. Goff, I thank you, and I'm not seeing her. I'm not sure if she's here, your ED, but the work at JIPO is really outstanding, and I really want to commend you, and I believe that the amendments here too will definitely put us in the right stead, and Jamaica will in fact be a force to be reckoned with in this regard. So with that, Mr. President, I believe that I was short enough, and I thank you.
Thank you, Senator Fraser-Binns. And short is relative. You tend to go a little longer than that. So I suppose that is the context in which I put it. Senator Braham.
Mr. President, when I became the chairman of the Urban Development Corporation, one of the things that I inquired about was whether the corporation had intellectual property, trademarks particularly, and what was the state of those trademarks. And it turns out that it does have trademarks, and you generally registered in Jamaica. Thank you. But further research shows that lots of persons have sought internationally to profit from the registered trademarks and the unregistered trademarks without the corporation's permission. And so there are marks related to Dunn's River, for example, and logos related to that entity. The UDC itself has trademarks and so on. Conference Center, all of those are trademarks, but persons have found them attractive. And so in some cases, we have had to do over the trademarks, do over the marks in an attempt to allow ourselves. As a matter of fact, in an occasion, somebody else had registered our mark and was seeking to charge us, meaning the UDC, to make use of it. And they weren't asking for a small amount of money. So we have had to go through a process of rebranding. And that has gone well, but for COVID, that would have been launched. But why I have said that, Mr. President, is that we then said, it's not enough to register these marks in Jamaica, because the abuse is not in Jamaica. The abuse is in Europe or the United States. Every time we have a visitor, that visitor makes a decision that when he or she goes back to from where she comes or he comes, they can take the mark with them and make use of it. So we said, let us then register these marks, these new marks, and some of the old ones in as much territories worldwide as we could. Well, we had to quickly abandon that idea because of the enormous costs that is associated with the registration of these marks, Mr. President. So there is no doubt, Mr. President, that the protocol in that case would serve as a cheaper alternative, a much cheaper alternative, and therefore the marks of the corporation will be better protected. Indeed, it is more likely that if the mark is owned privately, the vigilance in protecting those marks will be greater than if they are owned by the government. That's a fact of life. Sometimes in the government system, the marks are often forgotten, but there are other people who are making use of them. So I think that for marks owned by government agencies and so on, the protocol will be a godsend and will allow those marks, and in particular the corporations' marks, to be protected in the countries who are parties to the convention. And that's a good thing, a very good thing. And we appreciate that, at least I appreciate that when I saw the amendments, Mr. President. No doubt we have to bear in mind that there are some countries who are not a part of the convention. And in those cases, you either choose not to register in those countries or you do a private registration. And there are one or two major countries that are not a party to the convention, as I understand it. The other thing, prior to this, Mr. President, I happened to be employed to a law firm that did a lot of trademark work. And it involved the registrations, re-registrations, defense, and so on of these trademarks owned by international companies and agencies. And for those persons who participate in that part of the legal work, it does generate significant income, not only for the attorneys, but for the country. I mean, and every attorney have at least 2 staff or 1, and some have many more. So it is a significant. And I think that it is fair to say, when you look at it, that the convention will in fact wipe out that section of earnings for attorneys in the usual way. I really can't see it in otherwise. But the only other thought I had, Mr. President, is whether or not the benefit for the country as a whole outweighed the limited benefit to a single professional group. And when I speak to my colleagues, that's the best argument I can put. It's a very good argument in terms of business, and I demonstrated the benefit for the UDC, and that we will protect more property for business people as a whole. It will be left to the attorneys, Mr. President, to see what, with the help of JIPO, because of course JIPO will now earn some more from the process. There's no doubt, because they would be responsible for those international registrations, and a fee, no doubt, as recommended by Senator Fraser-Binns, will be charged for the purpose. But the attorneys will have to look and retool and see how best they can carry on business in that area for this particular piece of legislation and the convention, and how best they could generate income. I really do sympathize with them, because it is going to be a significant loss. I can't deny it. But I comfort myself that it is a significant gain for the country. as a whole. Then, Mr. President, the registration process will be quicker. All of these points have been made, Mr. President. And so, on the whole, I support the bill because I think even though it may not benefit me or my colleagues, it benefits the country. The other point that I want to raise is not exactly on the bill, but related. I met recently a young person, a youngish person, who had come up with an idea. And I won't say what the idea is for fear that it may be stolen. But they came up with an idea, and they wanted to protect it as they try to market it and get investors in it, to invest in it. And at the end of the day, they raised funds from friends and family and went and registered it with the U.S. Patent Office, a Jamaican. There are different levels of registration, but this registration gives that person a year or two to explore it and come for the next set of registration, which I'm not very competent to talk about. But the point about it, it struck me that there are Jamaicans who have ideas, and some of them, if they had the money, sometimes a small amount of money, relatively speaking, $500,000 or a million Jamaican dollars, to take it to the next step, to approach persons and so on, to try to develop the idea how better and how good it would be for the intellectual property development, ideas, patent registration under the new Patent Act, if and when it comes up, even trademark registration. And sometimes you listen to the idea, because you have been around a long time, you may not believe that the idea makes sense, except that if given a chance, some of these ideas would take root and take off and be a benefit to mankind. And there are Jamaicans who are in this position. And I would love us to be in a position where, if there is, I'll call the person an innovator. Could be a 40-year-old person, could be a 20-year-old person, or a 60-year-old person. It doesn't matter. But if they don't have that initial seed fund, they could go to somewhere, maybe a government agency, and receive a grant to do their preliminary development so that they can take it and pitch it elsewhere. I think it would do well, Mr. President. It's not a business. They can't say they have a business, so you're going to invest in the business. I think there may be like some angel funding for that type of thing. This is an idea, Mr. President. And if it is found that the idea appears to be promising, is either somebody steal it from them or it dies simply because they don't have that income to take it to the next step. Even pay the preliminary registration fee at the U.S. Patent Office. If the U.S. Patent Office accepts it for preliminary registration, it suggests something, at least to me, the layman. And I am told that there are young people in that position and that the world and Jamaica could benefit from it. And I would love to put it on the table for consideration. I understand the negative that may come from the bill, Mr. President, but I think the positives far outweigh the negative, and therefore I support the bill.
Thank you, Senator Braham. Minister.
Thank you, Mr. President. I think we are all agreed that improved protection of the intellectual property of our intensely creative body of people we call Jamaicans. That is a critical thing for us to achieve as we seek to achieve sustainable and inclusive economic growth. And certainly, harnessing our creativity will be better achieved when we have passed the bill that is before us today. I want to just address a few issues that have been raised in closing before we go to committee. On the matter that was raised in respect of protection for attorneys who practice in the trade, questions regarding how they will be treated once the amendments are in place and once we have acceded to the protocol. I just want to share that the language that was referred to in respect of Antigua and Barbuda, that is in fact already in the trademark rules which exist. It's in Rule 9. So that is there and will continue to be there in respect of national registration. And certainly in the rules that will be promulgated or that are already in draft form to support the Madrid Protocol itself, attorneys who practice in the area will be recognized as trademark agents. So there will be some grandfathering or transitioning. There won't be any additional qualifications for them. But certainly it is positive to recognize that we would be creating a new area in which young people can develop expertise, young and not so young in fact, but who are not necessarily attorneys at law. So it's an additional area of growth, an additional area of expertise, an additional area in which persons can seek employment. And as a small country, we must always be seeking to expand, not to contract and always protect as a knee-jerk reaction. Although this bill could never be seen as knee-jerk because it has been in gestation for a significant period, during which the concerns of the attorneys at law have been vigorously advocated for more than a decade and have been heard and considered. So just wish to say that that protection is there, but the emphasis is on growth and expansion. Regarding the query raised in respect of the protection for traditional knowledge and culture of indigenous and local communities, that this is in fact a recognized body of practice within IP law. And there is a body of practice that has been developed by WIPO, and there's a practice note that has been in effect used by JIPO to address these matters since 2012. So that exists, and that has been guiding applications which have been coming into the JIPO in respect of these matters. And essentially, largely these matters address language and cultural knowledge and symbols of the Maroon and Rastafarian communities. Those are most what are raised, the most well-known and the most active areas of practice in respect of Jamaica. And therefore, the criteria are established. Persons who address these matters, they know to go to the communities and get the consent of persons in leadership where they are seeking to have legitimate use. Because the issue is to ensure, not to prevent them from being used, but to prevent them from being misused, because it will allow the communities, and has been allowing the communities, to leverage their own IP assets as well, and sources of earning for them. In respect of the reference to the absolute refusal, mandatory refusal of registration in respect of national symbols, that has been the proviso, that is, that consent can be obtained. That has been in place since 2013 under the Trademarks Amendment Act 2013. So that's not something new that's being introduced by this bill. There has been a provision for approval, and that is managed by the Office of State Protocol, which sits within the Office of the Prime Minister. That is, they have their detailed guidelines and codes of practice which exist, and that is how that area is managed. JIPO is guided by them consent and approval has to be demonstrated as coming from the appropriate state authority, and of course the state authority consults with entities such as the Heritage Trust and otherwise in order to make sure that they are entering into, or any approval which is granted is appropriate. Regarding the phrase real and effective industrial or commercial establishment, this is actually a term of art taken from the Madrid Protocol itself. And it just generally means a real business. So not a shell company, not just a name that has been registered, pulled off the shelf by a company, by a law firm that registers shelf companies, but an actual operating business. So it's a term of art, and the practice in respect of the use of this language is well established globally and is used in the context of the normal meaning of the words as they exist. And also on the matter of fees, I just want to clarify that the Madrid Protocol fees are set by WIPO. So they're not set by the national offices, while local trademark fees are set by JIPO, who continues to aim to balance revenue generation with affordability for local MSMEs, entrepreneurs, and industries. In terms of the general approach to revenue loss or revenue fallout, I did mention before that cost-benefit analysis had already been done, and it had been done. I'll just add to say that as recently as 2017 considering revenue earnings from 2017 to April 2020, an assessment was done of the sources of revenue, that is from local filings versus international filings, etc. And it has been assessed on a whole that even if there is any small initial fall-off, it is not likely to subsist, and it has not been experienced elsewhere. And in fact, we've just had confirmation, I'm not sure where the information came from in Trinidad or what revenue was being referred to, because the remark made was general. But their intellectual property office has indicated that while they had a small fall-off in respect of patent revenue over the pandemic period, in respect of trademarks, they have actually had a 20% growth in revenue. And this is, in fact, what has occurred in 95% of the countries that have acceded or become party otherwise to the Madrid Protocol. Yes. Even in Kenya, they reported that what happened is that the revenue, while it might have fallen in one aspect, it increased massively in other areas because the companies continue to register. 95%. In Trinidad, it's a 20% uptick in 20% uptick in trademark revenues, trademark filings, 20% in Trinidad and Tobago. The 95% was a general growth reference in respect of countries that have acceded to the protocol over there. 95%. Sorry, no, that I don't have. That 95%, not 95% growth, 95% of the countries that have acceded have experienced growth in revenue rather than reduction. Not a 95% growth in revenue. Right, not so sure. So we are optimistic, but we're not unrealistic about what is taking place. But again, generally, we have reaffirmed that there will continue to be work for the legal fraternity because objections, corrections, and such matters will continue to take place and to require local advice and local professional advice. What we are saying, however, is that the broader balance, the benefit to the business community, the benefit to our entrepreneurs, the benefit to our sporting professionals, the benefit to our creatives, that benefit and their potential for growth is so exponential that one could never, as a government, consider the entire universe of what can be achieved by better protecting our intellectual property simply by focusing on one sector. And it is not felt that that the imbalance that any imbalance will be created, and we do, in fact, anticipate positive benefit to Jamaica as a whole. So another area in which it will assist us is ease of doing business. So when we speak about the fact that, in fact, I believe the comment was made that it's not an easy process because there are difficulties that can occur in different countries, etc. That is the same. Those are the same realities which will cause revenue to be earned here, but it's also part of recognizing that yes, this will solve a lot of issues. It will result in ease of doing business improving in Jamaica, and it will attract more companies to Jamaica in terms of registration. And this is where 95%, this has been the experience of 95% of the countries who are party to this protocol. So, Mr. President, I believe that we are at a good place to move to committee now and ask for, therefore, second reading of the bill.
Thank you, Madam Minister. The question is that the bill entitled An Act to Amend the Trademark Act be now read for a second time. Those in favor? Against?
A bill entitled An Act to Amend the Trademarks Act read a second time.
The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. I put clause 1. Those in favor? Against? I put clause 2. Those in favor? The ayes have it. Do I have the agreement of the leaders to put clauses 3, 4, 5, 6, 7, 8, and 9? So I so put clauses 3, 4, 5, 6, 7, 8, and 9. Those in favor? Against? Ayes have it. With the agreement of the leaders, I put clauses 10, 11, 12, 13, 14, 15, and 16. Those in favor? Against? Ayes have it. I put the title and enacting clause. Those in favor? Against? Ayes have it. The question is that I do report the bill as having passed committee stage without amendment. Those in favor? Against? Ayes have it. Minister?
Mr. President, I ask for third reading of the bill.
Members would have heard the question that the bill entitled An Act to Amend the Trademark Act be read for a third time. Those in favor? Against?
A bill entitled An Act to Amend the Trademarks Act read a third time and passed.
Thank you very much. Minister Samuda, under normal circumstances I'd have taken a break now, but we started a bit late, so I'm going to ask the Minister just to push ahead, and if necessary during the course of the afternoon we'll take a break. Is that okay? Mr. Bunting? Minister Samuda. Mr. Samuda, just 1 minute. Just before we begin, the new ambassador from the Dominican Republic, Mrs. Angie Martinez, paid a courtesy call on me a short while ago, and she is sitting in the gallery, and I would ask the members of the Senate to recognize her. Told that she's not only the first female ambassador from the Dominican Republic, but the first ambassador in 10 years, the first ambassador to pay a courtesy call and present her credentials on our Honorable Minister, Kamina Johnson-Smith, at the new Foreign Affairs building. Senator Samuda.
Thank you, Mr. President. Mr. President, I rise to commence the debate on the bill entitled the Criminal Justice Suppression of Criminal Organizations Amendment Act 2021. It is not my expectation that it will be a contentious one, and from reading the notes and the report of the Joint Select Committee, I see where much was discussed and much consensus was arrived at. But we know how things are in this chamber from time to time. But I do expect no man, I suspect it will be a smooth evening, but we see. The Senate should recall that the Principal Act was passed in 2014 as the Criminal Justice Suppression of Criminal Organizations Act, sometimes or rather commonly referred to as the anti-gang legislation. It is so called because the act was tailored to undermine criminal organizations by criminalizing the participation in and promotion of the activities carried out by such organizations. In that way, and as Senator Bunting would have mentioned in the lower house when he would have first carried this legislation, it is similar, certainly in its intention, to the RICO, Racketeering Influenced and Corrupt Organization statute in the United States, which has been instrumental in winding up several criminal organizations in that jurisdiction. The genesis of the principal legislation lay in the 2013 National Security Policy, which identified organized criminal groups as a Tier 1 threat to Jamaica. It was determined that the activities of these gangs undermined public order, citizen security, and socio-economic stability, and they are primary contributors to the rates of violent crime that has held Jamaica as an unfortunate outlier among nations in its rankings. The principal legislation at Section 21 stipulates that the Act shall be reviewed by a Joint Select Committee no later than 3 years after the date of its commencement. After its commencement, on October 24, 2018, the JSC held a total of 20 meetings and came to a close on January 28, 2020, through the process of review and consultation. The JSC developed proposed amendments to the Act that resulted in the Criminal Justice Suppression of Criminal Organizations Amendment Act 2021. The House of Representatives subsequently deliberated on this bill and made further amendments, which I will later identify. In its process of review, the committee considered submissions and presentations from the Ministry of National Security, the Jamaica Constabulary Force, the Major Organized Crime Agency and Anti-Corruption Agency, and the Office of the Director of Public Prosecutions and the Norman Manley Law School. Mr. President, the principal legislation is amended to reflect the recommendations of the JSC, but should also be noted that the Ministry considered subsequent court judgments related to the 2014 Act, as well as further consultation with key stakeholders involved in operational activities. Thus, some additional recommendations were made to further strengthen the legislation. Among the most important considerations throughout this process, Mr. President, is how seldom the principal legislation has been applied in the courts between the time it came into effect and the period of JSC review. Before the JSC commenced, the courts had only handed down 2 convictions based on the Anti-Gang Act, and as a result of guilty pleas, primarily related to the Uchen's Wilson trial coincided with the JSC, and several people were convicted under offences under the Act in that trial. Consequently, the potential of the legislation to undermine organized crime in Jamaica has not yet been fully realized. Mr. President, it is worth noting that the comparable RICO statute in the US was seldom used in the first 10 years after its adoption in 1970. It was actually during the 1980s prosecutors discovered its true potential and the number of RICO cases increased dramatically. By 1986, US prosecutors had major cases pending against 17 of the country's 24 mob families. The statute allowed New York prosecutors in 1985 to win indictments against the heads of the city's 5 mafia families, as it allowed the U.S. attorneys to connect all 5 families in one coordinated enterprise. Mr. President, Jamaica remains inordinately plagued by the activities of organized criminal gangs. According to JCF statistics, there are 379 gangs present in Jamaica, of which 262 are considered active. Moreover, for the year 2020, JCF has assessed that 802 of the murders that plague this country were indeed gang-related, which is 61% of the total for 2020. Now, what this study doesn't deal with, and we can go into later, is the number of gangs which have been fragmented for a number of reasons and the average size of membership. That is another layer to be looked at. The several security phases, as I would call them, that we have been through since 2010 would have changed the dynamics of both how gangs are constituted and how they operate in many phases. I mean, that's on the basis of the legislative changes we have made since then. It's based on operational changes. It's based on use of particular legislation. And there's a whole dynamic, and we have to appreciate that crime and the security situation certainly isn't static. Many of the murders, and referencing the 2020 numbers, would have resulted from inter-gang and intra-gang conflict. To fund themselves, we know that these criminal groups also engage in activities that are incredibly detrimental to the wider public and to Jamaica's development. These activities, as identified by the JCF, include contract killing, extortion, robberies, and drugs and firearms trafficking. Therefore, it is of paramount importance that we not just prosecute these individual offenses, but target the criminal organizations themselves through legislation. Mr. President, the government has had some success in disrupting and halting the activities of many criminal gangs in particular hotspots. But I think it is important to note that as we apply pressure to criminal gangs and those who would seek to harm and to harm Jamaicans, that no single piece of legislation is indeed the silver bullet. It is a suite of measures, and the legislative agenda, partially that would have been outlined by Dr. Chang in his sectoral presentation, that we believe we will further strengthen the total ecosystem to fight crime in this country. Legislation then has to be coupled with investment, it has to be coupled with organizational adjustment, and it has to be coupled with resolve. I believe we have the resolve and the necessary investment, and organizational adjustments are indeed being made. The goal, Mr. President, is simply to bring down the number of criminal organizations in the country and the number of participants in criminal activity. If we succeed in that, there will definitely be fewer enterprises that thrive on crime and thus lower rates of crime overall. I think it was useful to insist on reviews of the legislation when you would have done it, because as I said, crime and the situation facing Jamaica will never be static, and I think if we're to disrupt organizations that continue to change and continue to evolve, we're going to have to ensure that legislation is always indeed fit for purpose. Therefore, Mr. President, this afternoon I ask my colleagues in the Senate, as they contribute and as they consider the bill before us, to indeed pass the amendments. These specific amendments are designed to address the weaknesses in the principal legislation that we believe led to its underutilization in the courts. We believe that passing these amendments will sufficiently augment the Anti-Gang Act, as it's commonly referred to, while including appropriate safeguards to bring it to its true potential as a legal tool for that the justice system can indeed employ in its fight against organized crime. Mr. President, the bill was debated in the lower house on June 1st, 2021, and passed with 4 amendments. I will now take the Senate through the clauses of the bill as well as the amendments to the bill passed in the lower house. As a general amendment, Mr. President, all references to serious offense have been replaced with reference to applicable offence pursuant to the recommendation of the Joint Select Committee. The use of the term applicable offence in place of serious offence would facilitate the inclusion of offences that may not be classically considered as serious offences. Further to this, the committee accepted a recommendation to amend the first schedule of the Act, which is entitled Serious Offences, to include larceny and receiving stolen property, since criminal gangs are known to engage in these activities as primary criminal enterprise. Clause 2, the amendment of Section 2 of the Principal Act interpretation. Section 2 of the Principal Act is amended by inserting a definition for the terms applicable offences, conveyance, and vessel. In light of their usage in the Act, it was necessary to define those words to ensure that they would be interpreted in the context intended. Consequent on the replacement of serious offence with applicable offence, the definitions of criminal activity and criminal organizations were also amended in Section 2. In addition, the definition of law enforcement officers has been amended with the deletion of reference to Island Special Constabulary Force. Having regard to its administrative merger with the Jamaica Constabulary Force, there is no longer a need to make reference to that entity. Section 6 of the Principal Act has been amended by inserting a new paragraph which empowers the court to take into consideration any symbols or markings or in the possession of a person that indicate a link in or involvement or indication with, or identification rather, with a criminal organization. This can therefore be used as a basis for determining whether a person is a part or a participant in a criminal organization. In addition to this, the word "and" at the end of Section 6.3f has been deleted. This amendment is aimed at removing the uncertainty concerning whether the provision must be applied conjunctively. In this regard, any of the factors listed at Section 6 may be taken into account by the court in determining if a person is a part of a criminal organization. Similar to the amendment at Section 6.3f, both Section 7.3b and 8.4a have been amended by removing the word "and," which appears at the end of the respective paragraphs to make the list of factors the court takes into account read disjunctively. The Principal Act has been amended by the insertion next after Section 8, a new Section 8a. This new section provides the offence of using a premises or conveyance for purposes which constitute an offence under this Act. It will be recalled that the Joint Select Committee recommended a creation of a new offence for using any premises in furtherance of gang activity, similar to what obtains in Section 5 of the Law Reform Fraudulent Transactions Special Provisions Act. The intention for the introduction of this new offence is to capture those persons who knowingly cause or permit the use of a conveyance or premises for the commission of an applicable offence. The security forces have highlighted that in many instances, criminal organizations have utilized premises and conveyances to conduct their criminal operations. These premises and conveyances are a critical part of the day-to-day operations of the criminal enterprise, and the facilitators must therefore be targeted. The new Section 8b, similar to Section 15 of the Law Reform Transactions Special Provisions Act, provides direction to the court on how to treat with the fact that the possession of property not accounted for during a trial for an offence under the Act. Section 11 of the Principal Act was deleted and substituted with more expanded provision. This new provision sets out the circumstances within which the offence of professing to be a part of or a participant in a criminal organization to obtain a benefit can be committed. If a person professes, whether by statement or suggestion, to be acting on behalf of or on the instruction of a criminal organization, he would now be captured within the provision. The section now reads, 1. A person shall not, in order to gain a benefit, profess to be a part of or a participant in a criminal organization, or to be acting on behalf of or on the instruction of a criminal organization, whether by A, telling anyone that the person is a part of or a participant in a criminal organization, or is acting on behalf of or on the instruction of a criminal organization, or B, otherwise suggesting to anyone that the person is a part of or participant in a criminal organization or is acting on behalf of or on the instruction of a criminal organization. As agreed at the Joint Select Committee, colleagues, Section 15, Offences and Penalties, second schedule is amended at subsection 2 by expanding the list of aggravating factors that should be considered at the point of a sentencing for a person, at the point of sentencing a person for the commission of an offence under the Act. These aggravating factors include if an offence under Section 4, which is the offence of recruitment of a child to a criminal organization, involves aiding, abetting, inciting an act of violence as a part of the process of recruitment. If the commission of an offence under the Act is done whilst being in possession of any item of dress designation or description of a law enforcement officer, recruiting a child on the premises or grounds of or within 300 meters of a school or any other educational institution. If an offence under Section 12 is committed against a child, involves aiding, abetting, inciting, or inducing an act of violence in order to prevent or obstruct a person from ceasing to be a part of a criminal organization or to provide benefit to a criminal organization. It should be noted that with the creation of an offence at new Section 8A, for using a premises or conveyance for purposes which constitute an offence under the Act, this new Section A also included in the list of sections which committed by a foreign national would be treated as an aggravating factor. The inclusion of this provision, Mr. President, is to account for foreign criminal actors involved in transnational organized crime. As noted in the national security policy, if organized crime is left unchecked, the very survival of the state will be at risk. However, in the lower house, it was agreed to delete the words, "not a citizen of Jamaica," and substitute, therefore, the words, "not a citizen of Jamaica or ordinarily resident in Jamaica," and further expanding the reach of the provision. Section 17 of the Principal Act is amended by replacing a marginal note, quotes, "trial procedure," with "mode of proceeding." It will be recalled that the committee considered the matter of witness protection and the need to ensure the protection of the identity of such persons before, during, and after trial. In this regard, the committee recommended that Section 17(2) be expanded to allow for the protection of witnesses involving in cases cases being prosecuted under the Act, therefore during and after trial. The section is amended in subsection 2 by deleting the words, "hearing a case in the exercise of its jurisdiction under this Act may." The section in part now reads 17(2), in the interest of the administration of justice, public safety, public order, or public morality, a court that has jurisdiction to hear any case under this Act may, at any stage before or during trial, and with effect for such duration as the court thinks fit, including any period of time after the conclusion of the trial, direct that the identity of any person, including a witness in the case, shall be protected in a manner specified by the court. The penalty provision at Section 17(4)(a).
Mr. President, the time being 1:20, I ask that the Senate be allowed to sit beyond 1:30 p.m. to complete the business of the day.
Thank you very much. Members would have heard the question. Those in favor?
Aye.
Against?
Mild assistant.
Senator Hill, would you replace your mask, please?
He's speaking to all three of us. Put on your mask, please.
The penalty, Mr. President, at Section 17(4)(a) for publishing any information in contravention of a court's direction was also amended to increase the monetary penalty from $1 million to $3 million. The current fine was not considered as a sufficient deterrent, especially given the nature of the offence. The first schedule of the Act, which outlines what is now the applicable offences, has been amended by including reference to Sections 48, offences in connection with lotteries, 49A, licensing of lottery agent, and 56, offences in relation to pick-up, PO, and drop ban of the Betting, Gaming and Lotteries Act. The rationale for the inclusion of these sections comes from the current trend of less organized criminal networks orchestrating informal lotteries and using the proceeds from these activities as a source of income. The introduction of these provisions will serve to decrease the profitability further of these activities. Reference to sections 6, 7, 15, 18, 19, 34, 35, 38, and 41 of the Larceny Act has also been included. The offences under these sections, for example, larceny of cattle, larceny from the person, larceny of cattle and larceny from the person have been highlighted as commonplace activities of criminal gangs. Several of these gangs have pinned their survival and financial gains on committing many of the offences, including robberies and predial larceny, for the continuation of their criminal enterprise. Considering this, the inclusion of these provisions was deemed necessary. The first schedule, colleagues, was further amended with the inclusion of Section 3 of the Explosives Control of Manufacture Act, no explosives to be manufactured without license. Section 14 of the Gunpowder and Explosives Act. Sections 29 and 30 of the Offences Against the Persons Act. And Sections 10 and 11 of the Malicious Injuries to Property Act. It has been noted that these types of activities are carried out by criminal groups. The inclusion of these provisions stems from an incident in 2017 in the parish of St. Anne, where fugitives utilized hand grenades to aid in their challenge to law enforcement personnel. The incident resulted in the injury of a member of the law enforcement response team and highlighted the brazen use of explosives by criminal organizations. On the recommendation of the DPP, it was deemed appropriate for these provisions to be included. The first schedule was also amended to make reference to the Fisheries Act, 2018, since the Fishing Industry Act was repealed and replaced by that act. As such, the provisions listed in the Principal Act are no longer valid. In light of this, the bill takes into account the offences outlined in the new Fisheries Act. The second schedule, Offences and Penalties, has been amended, taking into account the additional new offences. The penalty for the new offence created under the new Section 8A, offence of knowingly causing or knowingly permitting premises or a conveyance to be used for any purpose which constitutes an offence under this Act, has an applicable penalty of a fine or a term of imprisonment not exceeding 15 years on conviction on indictment in a circuit court. The Constabulary Force Act has been consequently amended to include a new Section 17A to allow for the application to a Justice of the Peace for a warrant authorizing a search of a building, receptacle, or place specified in the warrant and seizure of any item specified in such warrant. I know Senator Sinclair had raised a concern with the inclusion of place. I hope that the explanation was satisfactory in that space. We felt it was necessary to broaden the powers and to ensure there were no issues in the exercise of these powers. The Constabulary Force Act is also amended in Section 2 by inserting definitions for the terms conveyance and vessel in light of their usage in the new Section 17A. It was deemed necessary to define the terms to set the context in which they are intended to be used. It should be noted that the Joint Select Committee report prescribed that only a constable named in a warrant could give effect to the warrant. It was subsequently recommended, however, that this limitation be removed, as it may pose operational challenges to the work of the JCF. There may be instances where the constable named in the warrant cannot give effect to the warrant. In such a case, the function of the JCF would be hindered. Additionally, it is noted that in practice, the constable is not named in the warrant. In light of this, the prescription has been removed from the reformulated provision. 2 amendments to the proposed Section 17A6 of the Jamaica Constabulary Force Act were accepted and passed in the lower house. In this regard, on the recommendation of the JCF, that Section 17A6 is redrafted to reflect 6. Where a constable has seized anything under this section, the constable shall leave a notice in the prescribed form of the seizure of at the premises receptacle, conveyance, or place, as the case may be, from which the thing was seized, and as soon as reasonably practicable, A, if satisfied that there is no dispute as to the person lawfully entitled to possession of the thing, and 2, the continued detention of the thing seized is not required for the purposes of an investigation or any court proceedings in respect of the commission of any offense against any law. Return the thing seized to the person lawfully entitled to possession of the thing, or B, it's satisfied that there is a dispute as to the person lawfully entitled to the possession of the thing, and 2, the continued detention of the thing seized is not required for the purposes of an investigation or any court proceedings in respect of the commission of any offense against any law applied to a judge of a parish court for an order under subsection 8A or C. As it concerns the new section 17A7 and 17A11, it is noted that in the Joint Select Committee report, a person claiming to be lawfully entitled to the possession of a thing seized was only required to give 3 days' notice of his intention to apply to the courts for its return. After further consultation with the DPP and the JCF, it was gleaned that 3 days was insufficient time for the DPP to prepare its response to the application. As such, in keeping with the timelines used in the Civil Procedures Rule, the requirement as contained in this bill is at minimum 7 days' notice. An additional provision included is the new 17A12, which empowers a constable executing a relevant warrant to search any person found at the location, which is subject of the warrant. The inclusion of this provision aligns with similar search warrant provisions in legislation such as the Major Organized Crime and Anti-Corruption Agency Act 2018 17th Schedule. For practical application, it is considered useful and necessary to empower the constables to search persons present at a place in some instances. The evidence may be on the individual. The evidence indeed may be on the individual. I think, rather, this new section 39A introduces the offense of tipping off and establishes circumstances within which a person would not have been found to have committed the offense. A person commits the offense if knowing or having reasonable grounds to believe that an investigation is being conducted or about to be conducted in respect of any offense under the law, he discloses information relating to the investigation to another person. It should be noted that Section 39A differs from the formulation that was contained in the JSC report. The Section 39A, for Section 39A 2A, the provision now accounts for the fact that disclosure may be required by an order of the court or by another piece of legislation. The expanded provisions follows 39A1, which speaks to the disclosure regarding an investigation in respect of an offense under any law. Section 39A2A therefore had to reflect in a more general way the varied treatment of protected disclosures in all applicable laws. In relation to Section 39A2B, the proviso that the disclosure would not be protected if it were made with the intention of furthering a criminal purpose was included to ensure the provision could not be interpreted as an absolute protection to a disclosure made or by an attorney at law. This reformulated provision accords with the sections 97.3 and 104.4 of the Proceeds of Crime Act. Clause 14. The new Section 39B introduces the offense of falsifying, concealing, destroying, or otherwise disposing of documents or items relevant to an investigation. This offense targets activities that seek to thwart and derail criminal investigations. The applicable penalty would be to a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years, or to both such a fine and imprisonment at the parish court level. and at the circuit court level, to a fine or imprisonment for a term not exceeding 10 years, or to both such a fine and imprisonment. There were also consequential amendments to the Law Reform, Fraudulent Transactions, Special Provisions Act, Offences Against the Persons Act, and the Trafficking in Persons, Prevention, Suppression of and Punishment Act to amend the definition of criminal organization by replacing serious offense with applicable offense. This is in keeping with the amendment made to the term in the Criminal Justice Suppression of Criminal Organizations Act. In relation to the proposed Section 39B2 of the Criminal Justice Administration Act in the Lower House opted to delete the words "or suspect" and substitute, therefore, the words "or have reasonable grounds to believe." Mr. President, in closing, I think it's important to reiterate the importance of these amendments to refine and augment the legislative framework that we use to target these organizations. Through the consultations with stakeholders, we have ensured that the changes made were those that were needed to make the legislation useful for the police and the courts in targeting a criminal organization as a whole. The utility of the enhanced framework will be realized when our justice system has greater latitude to prosecute the entire criminal organization, thus dismantling the many gangs that plague our streets and terrorize our people. I look forward to the debate and invite my fellow senators to make their contributions. Thank you, Mr. President.
Thank you, Senator Samuda. Senator Bunting.
Thank you. Thank you, Mr. President. As the Minister outlined some of the background to the bill, it was a bill which I had a privilege to pilot in 2014 in the Lower House. But it might be useful to even go before that and understand some of the history. When I became Minister of National Security in January 2012, in one of my first meetings with the Commissioner of Police, I asked what was, there were maybe 40 or 50 pieces of legislation being worked on in the Ministry of National Security. And I asked him what was the most important, what would make the biggest impact on the GSCF's ability to fight crime, violent crime in particular. And he identified this anti-gang bill. And when his concern was primarily around dealing with the violent crime gangs, but because it was understood that there was indeed an overlap between white-collar crime and violent crime, and we felt it was important that in a sense, in alignment with the RICO-type legislations in North America and indeed across the world, that we wanted to create a new class of conspiracy-type offenses that would apply either to violent criminal organizations or to white-collar type criminal organizations, or as would often happen where you have an overlap, an entity that is involved in both. It gave no additional powers to law enforcement, no additional powers. And in fact, when we sat at the Joint Select Committee, a lot of the recommendations of various groups that came to us were seeking to increase the power to seize or search or etc. And in many cases, the Joint Select Review Committee referred them to other pieces of legislation like the JCF Act or the Interception of Communications Act, which would have been the more appropriate legislation to make those changes too. At the end of the day, I would say the report of the Joint Select committee reviewing this piece of legislation, the Criminal Justice Suppression of Criminal Organizations Act, basically confirmed that the act itself, the legislation, was quite strong. I mean, what we've been talking about here in the amendments bill is really tweaking, but the core of the bill was a very strong bill. So the question we must ask is, why has it not been more successful? And there's, of course, nobody more disappointed than me, because I put in a lot of work and a lot of time and a lot of priority on getting this act passed. The first reason, I believe, the minister has identified, and that is the unfamiliarity with the new law. It takes a while, particularly all the senior personnel who would have gone through training school and upgrading their training going along, they would be totally unfamiliar with this type of legislation, particularly since it was a pioneering legislation in our jurisdiction. But what that highlights is that it's just passing the legislation is not enough. We must have the training to support it, intense programs of training to get our investigators, to get our prosecutors, even the judiciary brought up to speed on these new pieces of legislation. The second reason, Minister, and I have received this both in discussions and listening to prosecutors as well as investigators, is that prosecutors often only go for the predicate offenses. They feel that, if possession of firearm or robbery with aggravation or shooting with intent is something they're much more comfortable prosecuting. And they worry that bringing in these anti-crime these anti-gang offenses will complicate the case that they have to present and might reduce their likelihood of success. So they basically tend to match the evidence with the easiest case that they feel they have a reasonably good chance of success of conviction. And in a sense that is understandable. But of course, what it does is that it removes often the much heavier penalties available under the Criminal Justice Suppression of Criminal Organizations Act. So persons who, if charged under that act, could be convicted and sent to prison for up to 15 years, or in some cases more than that, depending on the aggravating circumstances, will get off with only 5 years on the predicate offense. The third reason, I think, is that most investigators and prosecutors think of it in terms of the colloquial description, the anti-gang. So they think of it as something that you have a violent gang in Kingston or Mobay or Savlamar, and this is what the tool is for. But the tool is actually a much broader tool. It's for criminal organizations. And we had a recent case, for example, where it was clear to me as a person who had been involved in developing the legislation, a recent fraud case, but it was clear that it met all the elements of a criminal organization, but yet, again, only charged with predicate offenses, and the longest sentence of imprisonment imposed was 5 years, when it could easily have been significantly heavier under existing legislation, needed no new legislation. But Minister, I really believe that while those first three reasons are true, the strongest reason and the reason why we have had such disappointing results is that we need to build our intelligence gathering and our investigative capacities to penetrate these criminal organizations. That is why, Minister, we did not pass the legislation. We conceptualized and started the major organized crime and anti-corruption agency, MOCA.
Not MOCA first, but MOCA.
Not MOCA first, no. We started MOCA because we realized the sort of personnel that you needed to put together these cases was a very high-level person. Oftentimes, our investigators rely primarily on witness evidence, which is often unreliable, but even more challenging in anti-gang cases where persons, the threat of intimidation is heightened in that case. So really what you need now, a lot of, as is often used in the US, is that it's the money laundering aspect of criminal organizations that is usually challenged, because it's much more difficult to get particularly the leadership of these criminal organizations on the street level predicate type offenses. So prosecutors tend to go after them on the business side of their criminal organizations. And for that, you're going to need highly qualified forensic accountants, forensic auditors, for example, who would not normally be pursuing a career in the JCF. You're going to need highly qualified other forensic experts to extract, for example, cyber forensic evidence from their smartphones, their computers, their laptops. I recall when we had the famous Olint Ponzi scheme in Jamaica, we couldn't even mount a prosecution against them in Jamaica. And the principal was convicted in 2 other jurisdictions. And I recall in particular reading some of the documentation that was put in court in the United States. And there was no witness evidence that I can recall. It was all following the money trail. It was, they got the evidence, forensic evidence, the money laundering evidence from production orders served on the financial institutions, and then systematically pieced together all the wire transfers, etc., from agency to agency, bank to bank, individuals, etc., and created an impenetrable case, such a strong case that I think it was, plea bargained, and they got the conviction. And we have to develop that capability and that sort of practice in Jamaica if we're really to penetrate some of these criminal organizations, and particularly on the business side of their operations. Now, recently, there was an interview with the head of the Kingston Central Police Division, and she spoke to the 32 criminal gangs operating in that division. A little more than half of them, I believe, were what she described as active. Now, in the JCF statistics, last weekly statistics published, it shows murder up 29% year to date in that division. And undoubtedly it has a lot to do, or most of those murders, like the rest of Jamaica, have to do with those 32 criminal gangs. But it struck me that Kingston Central is one of the smallest police divisions. It doesn't have the challenges, Senator Sinclair, that St. James has, with, vast, many of them informal communities spread across all hills around Montego Bay. And that is still presenting a challenge to conventional policing. But Kingston Central is a much, much, much smaller area, all, formal roads, streets, and it's difficult to imagine that with, the proper application of CCTV, other technological devices and
Senator Bunting, what you fail to point out, within a stone's throw from the largest police station in the corporate area.
Thank you for adding that as well. Thank you for adding that as well, Mr. President. So it is perplexing that why in such a small police division we're having these fairly dramatic increases, 29% up in murders in that division, and we're not able to bring the proper intelligence gathering capabilities, the proper investigative capabilities to cut down on the rate of murders that's occurring there. And I know that some of the women from the community have been demonstrating in the precincts of Parliament on a Tuesday when the House of Representatives meet, really highlighting their plight and begging for attention and action from the Parliament. And I think this is one of the areas that we really need, Minister, some further concentrated attention. But as the Minister said, Mr. President, well, I'm glad you raised that, because I'm going to deal with it now. Most of the murders, as the Minister said, the majority of murders in Jamaica are gang-related. So it's appropriate for us to look at the statistics in terms of murders, violent crime generally, or what the GSF refers to as the Periodic Serious and Violent Crimes Review. This is from January 1st to January 5th. Undoubtedly, Minister, you would have it up to this morning, but this is almost the first half of the year. We have, or put this way, I have some interesting observations to make. And let me start with the positive observations, because I believe that we all have an interest in the success of the GSF and of law enforcement in this matter. Every one of us who have children or grandchildren or even businesses, Senator Webby, must be interested in this issue. Now, the positives is that murder, Senator Bram, is down slightly relative to the 3 previous years when we had SOEs. So, Mr. President, this year, with no state of emergency, we're doing better in controlling violent crime than we did under the 3 previous years with states of emergency. Well, it is, you'll get a chance to respond, and I'm sure you'll have a spin for it. But the reality is that as a government and as a country, our job is to look at the national picture, not just on any one picture. We have to look at the overall picture. And the truth of the matter is, those of us involved who have been involved with law enforcement at either the policy or the operational level are all familiar with the balloon effect. And if you squeeze one part of the balloon, it bulges out at another area. And that's what a lot of what we see when you have states of emergency in limited geographical areas. But the other thing that it does is, quite frankly, it diverts the attention of the police from the work of intelligence collection, from putting together tight cases that they can put people away for long periods with. Now, what are some of the other indicators, other than the statistics for murder, which is down slightly, minus 2%, and shooting, which is down 1%. The recovery of firearm and ammunition up this year relative to last year. No state of emergency, no random vehicular checkpoints, no violation of people's constitutional rights, and yet we're recovering more guns than last year and more ammunition than last year, year to date. What is interesting, Mr. President, is that arrests are also up significantly, quite significantly. 7,044 arrests year to date versus 5,331 last year. Now, this is an important statistic, but unfortunately, these numbers are less useful because the JCF refuses to disaggregate, as they had for over a decade before, the types of arrests, whether it was to do with the Dangerous Drugs Act, whether it was to do with the Firearms Act, etc. So it is difficult to know whether these are more serious offenses that we have seen improvement with, or maybe it is primarily things under the Disaster Risk Management Act, for example, which would not have as direct an impact on the crime reduction efforts. So, Minister Samuda, once again, the JSF was publishing these statistics for well over a decade. Why have they chosen now to try and suppress these statistics? It only makes it more difficult for all well-thinking persons in policymaking, in academia, etc., to draw conclusions about the effectiveness of the JCF's operations. And it is less helpful for us when we're debating it in this House. So there's also the other categories of serious and violent crimes are down. The public is most concerned usually with murder and shooting, the principal violent crimes. The other categories are down. But in percentage terms, while we welcome the small reduction, the truth is, in absolute terms, murders are still way too high. And they're much higher than any year during the previous PNP administration, when we had a fraction of the resources.
Notwithstanding the promise that you can sleep with your windows.
And notwithstanding the promise. So there must be something. If we can just put our egos down and stop being defensive, there must be something that we were doing right to get much better results in reducing violent crime with much fewer resources. And we have been making this suggestion, or various suggestions, and I really want Minister Samuda to, drop the Jekyll and Hyde approach to the opening and closing, and come with an open mind so that we can all contribute to fixing this. One of the things that I find very disappointing in the statistics, however, is the clear-up rates. What we see here for murder year-to-date, the clear-up rate is 34%. Of 579 murders up to June 5th, 197 have been cleared up. And Minister, you might remind the Senate of the definition of cleared up. But when we left office in 2016, well, for the year 2015, we were somewhere about 60% of a clear-up rate for murder. Sorry? Well, when you respond, I'm not.
Senator Samuda, inevitably you will have an opportunity to respond. Please allow the member to be heard in silence, as no doubt the courtesy will be extended to you.
So, but 34%, just 1 in 3. There's only a 1 in 3 chance of a clear-up. Now remember that many of these clear-ups are cleared up by the death of the suspect in those offenses, not necessarily because they're arrested, charged, convicted in a court of law. Shooting, clear-up rate, 35%. Robbery, 23%. Break-in, 32%. Mr. President, this reinforces my earlier point. that we need to invest in the investigative capabilities, the intelligence gathering capabilities, so that somebody must be more likely than not to be caught when they commit one of these serious offenses than it is now. Chances are they will not be caught now. Thank you. Thank you. Even Senator Floyd says he can see that we should be investing more in police boots than soldier boots. But again, coming back to what is published by the JCF, Mr. President, they have stopped publishing the category called sexual offenses against children. They've stopped publishing that information, which baffles me, because when I see what is covered in the media, in fact, some of the health practitioners say we're suffering from an epidemic of sexual offenses against children, an epidemic. Why aren't we publishing those numbers weekly with the statistics? They used to be published. Why are we not? A suggestion was made that, the public may not understand the statistics properly. That is why we don't give them. That's why we hide it. That can't be a legitimate reason. If you need to explain, put a key that explains what each of the categories mean, what each of the numbers mean, what each of the columns mean. That is more important to getting the information, more important in a transparent government than in being worried about whether people will misinterpret what you put out there. Now, the largest improvement, and improvement here means reduction in the numbers, is in the category of rape. And I don't want to discount good news, but as someone who follows data closely, Minister, and we have a background in quantitative analysis, whether in engineering or finance, this outturn seems a bit counterintuitive, and I don't know if there's an error there, but it suggests that the cases of rape, the number of rape offenses are down 44%. And the clear-up rate for rape is 96%. Now, I really hope that could be true. But, usually trends don't change like that. We were going along roughly about 50% clear-up rate for rape for many years, and then it's jumped to 96%. Is there some special explanation of what is happening? But the cases are down and the clear-up is up. I would ask you to just check those figures for me. I really hope they're correct, but they seem a bit counterintuitive. So, Mr. President, the opposition supports these amendments. Generally speaking, we were part of, instrumental in authoring the original bill. We were part of the Joint Select Committee that reviewed the bill. So we're not going to come here now and find fault with everything in the bill, right? I wasn't there. I would say, Minister, that there is while I understand the shift from what was serious offenses to now applicable offenses, because you want to throw the net wider, there is potential. I'm going to say no more than that. There's potential for abuse by investigators or prosecutors of this wider net. And let me use an example. For example, in the bill, you go into offenses under the Fisheries Act, I believe. I saw. You could help me, the section or the page.
60.
6D, right, on page 6. So, for example, any offense under the Fisheries Act would now be included in the applicable offense. So, and one of those offenses, for example, is fishing without a license. Now, if you have 3 young men who are out in a canoe fishing without a license, it would meet all the criteria, all the ingredients to making it theoretically an anti-gang offense. And I use an example that is, out there just to illustrate the point. But it leaves a lot of leeway and a lot to I assume it is left to the discretion of the judgment of the investigators, the prosecutors, and certainly if not by any of them, by the court when it gets there. But the net is very, very wide. But I understand that there's a challenge because if, for example, we have had boats from Central and South America fishing illegally in our exclusive economic zone, fishing off the Pedro banks, for example, taking huge value in our marine fisheries. And these are big organizations. These are not a couple guys with an outboard motor. These are huge trawlers with scores of people on it and big money behind it. So I see the benefit of having the discretion of now throwing the net much wider too, because they would definitely fit any international definition of a criminal organization. So I understand why it is, but I'm just a little cautious. But when we throw it so wide that it kind of really leaves it up to, theoretically anyway, leaves it up to abuse. But we're not going to make a big issue of it. I'm just pointing it out. Mr. President, each incremental piece of anti-crime legislation, while necessary to continue to evolve and to modernize and to improve and respond to the situation, the contemporary situation with criminal organizations. But each incremental one is subject to the laws of diminishing marginal utility. As I said earlier, I recall the Commissioner of Police saying that if only he had this piece of legislation, it would really go very far in breaking the back of criminal gangs. Hasn't happened so far. But the performance of this government in the era of reducing violent crime, whether through the use of this piece of legislation or states of emergency, whatever, it has been disappointing in the areas, in the main categories that frighten Jamaicans. The murder and shooting, especially as Lamy says, in light of the promise that Jamaicans would sleep with their windows and doors open. So I am encouraging the government, let go of the ego, let go of the need to defend whatever has gone in the past. Let us focus on what is effective. Stop wasting resources appealing the Constitutional Court's judgment on the SOE. That is a waste of resources. Let us put the time and the effort and the concentration instead on building the intelligence gathering and analysis capabilities in our law enforcement agencies, not just the JCF, but in MOCA, and in terms of intelligence, also in terms of the military intelligence. Let us share the data with the widest possible group of policymakers, academics, etc., so that you can have input of the best ideas from the widest possible range of persons, and let us adopt the best of these ideas so that our children, grandchildren, our investors, our communities can feel safe and can feel that we are jointly making progress in the battle against violent crime. Thank you.
Thank you, Senator Bunting.
Senator Charles Sinclair.
Pardon me? Thank you, Mr. President. Mr. President, the Criminal Justice Suppression of Criminal Organizations Act was reviewed by the Joint Select Committee. So, and as Senator Bunting in his comments made reference to the fact that there was a draft, things were being worked on from before his time, and he came and as Minister of National Security took the baton, did reviews to it, and got the legislation passed. And we are now here, having done the review and doing additional amendments under different administration. What that speaks to, Mr. President, is that although we are on opposite sides, that there can be a taking of a baton, improvements being made, and we continue the race in order to make Jamaica, land we love, a better place. And so that is something that we have to look at as government and as opposition in ensuring that we do what is expected of us that can yield better results. And in respect to this particular issue that we are dealing with, curb gang activity and other serious offenses perpetrated by gangs, which have caused tremendous pain to Jamaicans and to Jamaica. So, President, in respect to the particular bill that we have before us, I just wish to highlight a few of the clauses and to make comments on them. And I start first with Clause 3, Roman numeral, what's that, 4? H, that deals with the tattoos. And I start there because I was watching CVM and I saw and heard someone from the legal profession make a comment that would have been heard by everyone watching CVM, and because it can be repeated on YouTube, etc. I mean, it can spread far and wide. Where that person sought to give the impression that the mere wearing of tattoos would bring you under this legislation and can lead to you being prosecuted. And I don't believe that that is the intent of the legislation, and in fact would not lead to someone being prosecuted under the, and I will refer to it as the anti-gang legislation for short. So I think that that needs to be cleared up. The wearing of tattoos without more would not cause one to be designated a member of a criminal organization. Well, I have said it, and we will highlight it. Clause 6, Clause 6 of the bill that is before us, Mr. President, which seeks to amend Section 8 of the Principal Act by adding 8A, where this clause proposes to make the owner, occupier, or any person responsible for management of any premises or conveyance liable if he knowingly causes or permits the premises or conveyance to be used for any purpose which constitutes an offense under the Act. There is a provision also under the Principal Act, which is Section 10(2), which speaks to harboring of persons who are found to be part of a criminal organization. But the general offense of harboring is one that is still left to our common law. It's a common law offense. Under this particular legislation, it comes with serious consequences to harbor or to facilitate someone who is a member of a criminal organization. The penalty, I believe, goes up to 20 years if you are convicted for that particular offense under this legislation. But, you know, when we hear the stories in relation to criminal activity and persons who continue to harbor, and harbor does not just merely mean that you provide accommodation in the form of a living space for an individual. It covers a wide range of things in respect to providing for their sustenance. And so what I am submitting, and I understand in a discussion that I had with persons from the representatives from the Ministry of National Security, is that it is intended to codify the offense of harboring, but it should come with heavy penalties, Mr. President, and I believe it will go far. That once the police indicates through whatever media that a particular individual is a fugitive, that you will get the cooperation of even the mother to say, look here, let me take you in, and so that the process can run its course. You may end up being acquitted, not even charged. You may end up being convicted for the offense that you are placed before the courts for. But that may be the justice of the case. And so I believe that we should look on in a broader way, beyond this legislation, on the offense of harboring, because I do believe it will assist the police in ensuring that persons who they have an interest in will be brought to them in a much speedier time than what we find. Now, when you look on what is being done presently by the JCF, they put out something called, on Wednesdays, Wanted Wednesdays. And I think they have gotten significant response from the public in respect to that. Just putting out the information, and the public has responded, and many persons whose faces have appeared in that forum, they have been brought in, or they turn themselves into the police for the process to take its place. So, President, in Clause 9, 2D, I would just ask the Minister when he responds. It refers to the aggravated situations where a person is found in possession of any item of dress, designation or description of a law enforcement officer. If included in that would be persons wearing the armored vest, what we generally describe as the bulletproof vest. And if it is not a consideration, then I'm going to raise it when we get to the committee level. Mr. President, similarly under under Clause 9, and I look on letter E, aggravated offense again, and it speaks to persons who are not a citizen of Jamaica or ordinarily resident in Jamaica. It says that those persons shall be liable to imprisonment for an additional term not exceeding 10 years. Another aggravating situation that can lead to that penalty being attached is if you commit the offenses referred to under the legislation on the premises or grounds or within 300 meters of a school or other educational institution, and whether it is committed against a child. That can give you an added sentence. The problem I have with it, and because when you look at them, school, which should be a protected area, children, vulnerable class of persons, and someone who is not a Jamaican, but coming into our space and committing these applicable offenses. And it says that they shall be liable to imprisonment for an additional term not exceeding 10 years. So that means that it can run from 0 to 10. Because of these special circumstances, I believe, Minister, that we should be looking at a minimum sentence for this particular offense. They are special, it's aggravated, it should not be left to the discretion. We as legislators must send a signal. You can't come into Jamaica, come into our space as a foreigner and commit offenses. Don't commit the offenses against children and let us protect the sanctity of our learning institutions. It's something that I put on the table for consideration. Clause 10 speaks to the protection of witnesses, and the fine has been increased to $3 million in the event that certain things are done which breaches orders that are made for the protection of witnesses that are vulnerable. And Mr. President, many cases, in fact, a case under the anti-gang legislation that was before the courts, crumbled because the witnesses could not be found. And so we have to do everything, and legislation has been passed over the years. Video link, evidence can be given by video link, means of video link. There have been other amendments to the Evidence Act, which allows for statements to be put in without the witness actually being present in court. And we have strengthened the witness protection program. And now we are seeking to increase the monetary fine under this particular legislation, which I say is highly commendable. As I said, many cases have crumbled because witnesses become fearful. And the mere publication or allowing someone to know the identity of a potential witness can lead to persons apprehending fear and just disappear off the radar. And that was one of the concerns. So I commend the increase in penalties in that regard under Clause 10 of this particular bill. Mr. President, Clause 13, which speaks to the Justices of the Peace, which proposes to amend Section 17 of the Principal Act and speaks to Justices of the Peace being involved in the issuing of warrants for searches. Mr. President, the Justices of the Peace I am submitting must acquire the habit of taking copious notes when issuing these warrants, very detailed notes. And they must be appropriately trained and they must be objective. Listen to what is being put before them by the relevant law enforcement officer and to ensure that they arrive at their decision in a most judicious way. They must not merely be an arm of the law enforcement. They must be fair, independent, and as I say, judicious in the exercise of their duty. Mr. President, some general comments. In preparing for this particular debate, I in doing some research, came across a print from the Public Opinion newspaper, which was published February 11, 1972, and it had the following headline: "Crime wave hits Mobay and may ruin tourist trade. Citizens sending deputation to Home Affairs Minister." In the actual story, Mr. President, these words could be found. Montego Bay is now in the grip of a serious crime wave, which leading citizens feel can no longer be hushed up. Criminal gangs have taken charge of sections of the town, and in these areas the people are going about their business in fear. Rival gangs have been clashing with blazing guns. 1972. 1972. I moved from that and I went to a 2013 report of the Joint Select Committee of this Parliament, which considered the bill, which is a principal act, Senator Bunting. And in its introduction, these were the words contained. According to information revealed by the Jamaica Constabulary Force, Jamaica has the 4th highest murder rate in the world at 40 per 100,000. Between 1981 and 2012, Jamaica recorded 28,689 cases of murder, 40,879 cases of shooting, and 115,064 cases of armed robbery. 80% of all murders committed in Jamaica were gun-related. Data shows that the Jamaica police face an average of 500 gun attacks from criminals each year and lose an average of 15 members to criminal violence. So we moved from 1972 to 2013, and we now move to the report of May 27, 21, where the current Minister of National Security made this presentation to Parliament on this bill's debate. The latest statistics from the JSF shows that there are 379 gangs in operation in Jamaica. 262 are considered active gangs, which reflects an increase of 5% over 2019. Madam Speaker, for the year 2020, 802 or 61% of murders were assessed to be gang-related. These criminal gangs continue to create mayhem in our society and are the main drivers of the elevated crime rate. So we have traversed from 1972 right through to 2021. Mr. President, what it highlights to me is that from birth, unfortunately, Jamaica and Jamaicans have suffered at the hands of gunmen operating individually but primarily in gangs. The big question is, what are we going to do about it? And who will bell the cat, as it were? Mr. President, various administrations have implemented measures to include persuasion, legislation, squads, security measures, to name a few, to impact gang activity and the attendant criminal activity. The questions are, have we achieved the desired result? And can and will we achieve the desired result? Mr. President, it is my view that we cannot give up, and we shall not give up. What we need, Mr. President, is a sustained and coordinated effort by everyone, to include government, the opposition, the many law-abiding people of Jamaica, and we shall overcome. Mr. President, one can imagine the growth potential of Jamaica, the improvement to the economic and social well-being of Jamaicans, if we can significantly reduce gang activity, murder, and the commission of serious offenses. And Senator Webbage said to me this morning that he had a conversation with a leading hotelier and the potential growth that this country has in respect to the tourism industry and its ability to provide for Jamaicans, provide employment for Jamaicans, and to improve our position economically. It's something that if we were able to reduce serious crime, the situation that we have, we'll be able to achieve much. Mr. President, the coordinated effort of which I speak involves the people of this country. Parents must take advantage of the educational opportunities and social services available. It is my belief that many youngsters who find themselves gravitating or lured to a life of crime are from school dropouts. Administrations across the political divide have made available public educational institutions at primary and secondary levels for the education of our nation's children. In some institutions, principals have found their schools even underpopulated. I have had discussions with principals in certain communities, and we have heard it in Kingston, we have heard it in Montego Bay, where they actually go out on drives, seeking persons, students, to come and populate their schools. it is a strange scenario. Governments have paid out millions for school book rental programs and school feeding programs to ease the burden on parents. Mr. President, I would never for once suggest that one could easily argue that more can be done. Our parents must grasp the available opportunities with both hands. They must ensure their children get the proper foundation from which they can blossom and grow into worthwhile citizens and shun the lure of gangsterism. And it takes me, and I speak to that particular situation, Mr. President, because the comments that we have heard, the pool from which a lot of these gangs are formed, comes from our youngsters, 15 years old, and when you look across Westmoreland in recent times, several persons in that group have been caught in situations of crime, serious crime. In fact, there was a report recently, last week, where a 15-year-old and a 16-year-old were arrested for shooting at the police. And I take it further with the video that has been circulated with a youngster, Mr. President, where a youngster at 7 years old, in the presence of adults, laughing and finding glee at the comment, where a youngster could have in his mind. In fact, at my age, when I was at 7 years old, one would say, what you want to become? I want to become a fireman. I want to become a police officer. Kids weren't even thinking of being lawyers and doctors at that time. We were thinking of being police, soldiers, firemen. But we have these teachers, we have this particular situation, and I don't think that is the only situation. But, Mr. President, I spoke about dropouts, and I've said here already that in relation to education, the regulations under the Education Act is something that must be looked at, because in going through it once, I came across a provision, a section in the regulation, which said that if a child was missing from school for 30 days, he's deregistered. And I said to myself, why is that regulation contained in our education regulations? I would have thought it much better that if a child is missing from school for 3 days, the system, the guidance council, where they start from within the school, or the system is compelled to go out, to visit the home, to find the home, and to determine why that child is not at school. Mr. President, we have heard about truancy officers in the past. We need to bring them back in full force in the various regions whose job it is to ensure that all the nation's children are attending an institution of learning at the primary and secondary level. Mr. President, social services of this kind may unearth many situations within the homes that can be corrected at an early stage with a little help and guidance. There may be instances where parents and children may have to be placed in structured programs and monitored to ensure compliance. Mr. President, our primary and secondary schools must cease being a conveyor belt. No child, in my opinion, should progress year on year without establishing proficiency in the 3 R's of reading, writing, and arithmetic. Mr. President, I'm going to go into a little touchy area. And I say it is touchy because it touches upon our music. And Mr. President, the Honorable Prime Minister spoke on the topic, on the potential negative influence of the lyrics expressed by many of our local artists in music. The Honorable Prime Minister made a plea for greater responsibility on the part of artists in their musical expressions. I want to stand here and say, in respect to that plea for responsibility, I support the position of the Honorable Prime Minister. Mr. President, I have seen videos produced by local artists, connected to local artists, to support their lyrical content of the music. And those videos have portrayed young men with guns committing some of the most violent acts which are replicated in our communities. And I will give you one particular video that I watched, what was contained in it. We are a group of men armed with what they call the talo, went to a home in what appeared to be a low-income community based on how the houses were shown there. They kicked off the door, went in, there was a family on the inside. They took out the mail from the home. It's a video. It's a video, Senator Ali. It's a video. Took him outside, took him around the corner, and he was put on his knees and executed. That was in a video
for entertainment
that would have supported music put out by a local artist. Mr. President, we are told that the guns that are reflected in these videos are props. My question is, because those props, as I understand it, and the minister can correct me, and we have Senator Bunting, who was also a Minister of National Security. If they were imported with licenses from the Ministry of National Security, because you would have to get a license to import a prop which represents a firearm. If so, Mr. President, you should, yes. We're coming to that, Senator Bunting. If so, I want to ask him, why would our Ministry of National Security, if they issued a license for the importation of those props, why would they, in our context, facilitate such importation? Was the ministry not aware of the purpose for the importation, which is to make videos depicting extreme violence? And if they are not permitted, where is the clamor for the appropriate action? These questions require answers in the context of what is and has been happening in Jamaica for decades. Mr. President, I'll go further to say that there are some artists, and nobody can deny this, there are some artists locally who are the face of some of the known gangs in Jamaica, wittingly or unwittingly. They are the face of some of the gangs. In some quarters, the Honorable Prime Minister was supported in his comments, while others criticized. And that is all reasonable within our democratic process. Where I got the greatest surprise, Mr. President, was to see our colleague Senator Damian Crawford join the fray of those who leveled criticism at the Prime Minister. And why do I say that? In 2013, when the Principal Act was drafted, as Senator Bunting has indicated, by the previous administration, there was a bill. Inserted in the bill, Mr. President, was a clause 15, which not only sought to criminalize tattoos or other physical markings, colors, and dress, but also criminalize the recording and performance of songs which promoted or facilitated criminal organizations or their activity. I have with me a printout of the report, and when I look to this person's signature, who were members of the committee, at number 3, person who signed at number 3 was one member of Parliament, Damian Crawford. In supporting the clause, the government of the day of which Senator Crawford then was Junior Minister in Tourism and Entertainment, had the National Intelligence Bureau prepare a list of 103 songs released between 1991 to 2012, which contained lyrics which glorified violence, guns, gangs, and which contributed to the propagation of the anti-informer culture
on a point of order,
and could
Mr.
incite violent
on a point
behavior.
of order, Senator Sinclair is misleading the House. The government did not have such a list prepared. It was the JCF in making their presentation to the Joint Select Committee that produced that evidence. We didn't ask them to produce. They produced that evidence, this list of songs. So I just want to be accurate.
Thank you.
Proceed, Senator.
Mr. President, so the bill that was being put forward by the administration, adding that particular clause 15 to criminalize performance, recording of those songs. It was the strong advocacy of a civil society group, of the civil society groups, that is from the report, and the opposition members, Member of Parliament at the time, the Honorable Olivia Grange, and our now President, Senator Tom Tavares Finson, that kept the provision out of the Act. In fact, a minority report was prepared and presented as an appendix to the report that was submitted to Parliament. Right? So, Senator Crawford would have signed on what was being proposed, it never went in, etc. He never signed, he could have signed the minority report, couldn't he? Mr. President, if our leaders, as a matter of fact, Mr. President, I want to just look at, and I will read from the report something. As I said, opposition members spoke against it. But here it goes on page 16. On the other hand, the majority of members of your committee argued that there was a reason why, for example, films are rated worldwide and why limits are placed on what certain audiences are exposed to, and that was premised on the notion that cultural expressions reinforce behavior. Your committee heard that there was scientific evidence to support the notion that cultural expressions reinforce behavior, and that was evident in the results from various studies that had been done. It was also felt that if persons consumed a steady diet of messaging about killing informers and killing the police, etc., it would have an impact on people's behavior and consciousness. Additionally, it was felt that in Jamaica, where there is a high murder rate, there is a need to tackle those issues by changing the mindset. Of course, I agree. I agree with it, Senator. And Senator Bunting, you notice, I didn't call your name. But I just want to say something. I'm making a point that if from 1972, coming right through to now, we have been having this gang activity and it just increasing and increasing. What it is calling for, what I am reading into it, is that we have to have a strong approach. And when we speak as leaders here in Parliament and anywhere else throughout Jamaica, we must speak with one voice. And if the Honourable Prime Minister says, that these persons must be responsible in putting out their lyrical content and their artistic expression, what is there to criticize about that? What is there to criticize the Honourable Prime Minister in respect to that, to ask for greater responsibility? And we have a lot of reggae artists, dancehall artists, who are doing that. In fact, I commented Senator Bunting has taken, not Senator Bunting, Senator Webby. You see, it's why you have. Yes. but Senator Webby, you have taken on Ding Dong in Grace as an ambassador to promote the products of Grace. So there is benefit in being responsible and can be for great achievement for the resident. But you also get the benefit of not encouraging a certain type of attitude in our youngsters. And I don't want persons to say, well, let us look at what is coming from the United States in respect to film and so forth. These locals that live in communities that can be touched, influenced on a day-to-day basis, they can reach to the youngsters who gravitate into the space of being a gang member, as the case may be. They see those persons as their heroes. They are not separated from them. When you see somebody on a film, Rambo, and he walks around with a machine, there's no connection to him, you know. But there's a connection, a real life connection to the artists, the local artists in Jamaica. So ask.
Mr. President, the member's time for speaking having expired, I move that the member be allowed sufficient time to complete his presentation.
Thank you very much. Senator, you have heard the question. Those in favor? Aye. Against? Continue,
Thank you, Senator Bunting. So, Mr. President, our leaders should speak with one voice, and I believe speaking in one voice would make us stronger. A message of greater responsibility to those that can influence behavior, as I said, cannot be a position to be resisted. Senator Bunting spoke to the ladies that would come and demonstrate on the outside of Parliament because they want to see us in here do things in order to protect them in their space. And it takes us into legislation. Mr. President, I have my personal view, but my personal view is consistent with a petition that I am hearing. I haven't seen it, but I hear that there's a petition being circulated seeking to accumulate 15,000 signatures. And what is being proposed there is something that I support. An attorney said to me when I mentioned it to him recently, he said, but you have to be careful because remember that you come from the defense side. I said, but I'm a Jamaican first. Senator Bunting spoke about the prosecution want to focusing on the predicate offenses instead of going to the anti-gang legislation which carries higher penalties. Yes, yes. But how can we, what I'm going to suggest is that in respect to some of these offenses, and I'm going to go right to the Firearms Act, which is contained in the petition that is being circulated, asking for an increase. Presently it is life imprisonment, but then the courts interpret that in a particular way, and when they impose sentences, you get sentences for simple possession. Well, a well-publicized one, person got 3 years for a plea of guilty. But you find the range running in respect to sentencing going up to 10 years. Simpliciter, possession simpliciter. It is my submission, as consistent with what is contained in the petition. I didn't draft the petition, that there must be minimum sentences, significant minimum sentences for possession, illegal possession of firearm. Minimum. And I can break it down. So for instance, a person is found with a handgun. Minimum sentence, 20 years. You're found with the higher you go up in caliber weapon, then you will have minimum sentences for others. And you have the aggravating factors. So if you are found in a public place, it's an aggravating factor. If you are found in the vicinity of a school, an aggravating factor. Tack on some more years on it. If you are found in the vicinity of a church and place of entertainment. So, President, it stands to reason that other penalties under the Offences Against the Person Act would have to be amended. But let me tell you the benefit that you can get from it, as well as we can find a position which gives us some compromise. These minimum mandatory penalties will get the benefit of judicial discretion in the event of circumstances that are laid out under the Criminal Justice Administration Act or the Plea Negotiations and Agreements Act, which was recently passed in this place. So, if a person is found in possession of an illegal firearm and is convicted, he can be convicted by entering a plea of guilty. So he gets the opportunity of getting the discretion of the judge to say, all right, you pleaded guilty, you will not get the minimum sentence. Right, you won't get the minimum, which is 20 years. That's not a maximum. That is a minimum. Right? So you can get below that, yes. So you wouldn't get that. And guess where you get the second benefit of the judicial discretion? Because a lot of these persons who find themselves there are members of gangs, but they may be caught in a one-off type situation. And Senator Bunting, you want information? The gun court and gun offenses that you find a one person involved in, they are treasure troves of information that will be useful in prosecuting offenses under the anti-gang legislation. But guess what? In the circumstances that we operate in right now, a person says, well, Judge, go and give me 3 years, so I'm just going to rub it because I'm going to spend 2. So I'm not saying nothing to nobody. No. But you promise him 20 years minimum. I bet you my bottom dollar, him going to start to whistle and to say, look here, I have some information that will be useful to you. So we're going into the Plea Negotiations and Agreements Act. And unless there is something facing that individual, he will have no interest in providing you with information and intelligence that can be useful in support of the anti-gang legislation. So other legislation have to be used. It cannot just be that we are relying on this. Senator Bunting spoke about getting intelligence. We have to do what is done in the United States. When you're facing a significant time, you're going to start spilling the beans. And that is how we can start quickly, whilst we build up the ability, provide the law enforcement with the resources, and have them properly trained in order to garner information and intelligence through other means. Mr. President, I move on to another suggestion that deals with control orders, which I'm making a recommendation. The persons who gravitate to these gangs are what we classify them into being unattached youth. And we have heard about many programs being instituted by administrations, PNP administration, the JLP administration, both administrations. You have HEART. HEART was done by the JLP, the PNP sought to improve on it, and you call it, what, NTA? It's attached to that. We now have the Caribbean Military Institute. We have many training institutions across Jamaica. These unattached youths are a source of recruitment into gangs. Some of them may be gang members. They may not have crossed the threshold, meaning to say they may not have gone into the realm of having committed an offense, but they are part of the gang. The Jamaica Constabulary has told us on many occasions, they have given us exact number of gangs in Jamaica. They have told us that specific numbers of those gangs are not active. The use of the term gang, properly called criminal organizations, comprise of at least 3 persons under the legislation. So I take it that when the JCF is telling us that there are 300 and odd gangs, 367 gangs in Jamaica, they are telling us that they know at least 3 of the persons in order for them to say that there are 367 gangs. Simple deduction. When I look at Section 54B of the Criminal Justice Administration Act, which allows for restrictions to be placed on persons who are residing in Jamaica, but the restriction only applies to persons who are deported, to persons who have been convicted in a foreign country, but it is a view that those persons may pose a threat to public order and safety. Why can't we have an amendment of that legislation so that we don't have to depend upon the person being a deportee, nor that the person was convicted in a foreign country, but the person, based on the intelligence of the Jamaica Constabulary Force and other law enforcement agencies, they are a threat to public order and safety. The police have put them already, at least 3 of them, in gangs. Mr. President, the proposed legal framework of which I speak would merely be expanding the group or having new legislation that does not refer to the deportee and convicted person. Under the Criminal Justice Administration Act, what happens there is that an ex parte application can be made through the court that imposes reasonable conditions on the individual. In those circumstances, the social sector agencies and non-government agencies, as critical stakeholders, can develop programs and provide services to support the resocialization of the controlled person. That exists under the legislation presently. And if we just expand it so that we are dealing with persons who find themselves in gangs as defined, then I believe that we can have some amount of control. Under that legislation, the persons are required to live at a particular residence. They are required to comply with the strictures that are made out, the conditions imposed by the court. And I'm saying that if we do the appropriate amendment, we can have one of those conditions being that those persons must attend a learning institution, a training institution, or to get themselves being productive members of society. As it is currently, the voluntary approach for engagement attracts those who are willing to attend. What about those who, for whatever reason, decide that they are just going to stay on the sidelines and not voluntarily attend? How do we get them there? It is my submission that those persons may have to be nudged into a program that social services will tailor to his particular needs. These services, as I said, will involve training in all respects and, where necessary, psychological evaluation. Mr. President, in 2005, one minister said that young men within his constituency are irredeemable. I am not of that view, and I'm certainly not of the view that we can afford to continue leaving them unattended. Persons may raise the issue of constitutional considerations. This is something that I thought of in making the proposal. Mr. President, when we look at it, the legislation, Section 54B, has not been challenged in any constitutional court. It continues to exist in Jamaican law. And so, I found a quote from a particular case of Ryan versus the Attorney General, coming from a foreign jurisdiction, in which it says, "None of the personal rights of citizens are unlimited. Their exercise may be regulated by the legislature, and the common good requires this. When dealing with controversial social, economical, and medical matters on which its notorious views change from generation to generation, the legislature has to reconcile the exercise of personal rights with the claims of the common good, and its decision on the reconciliation should prevail unless it was oppressive to all or some of the citizens, or unless there is no reasonable proportion between the benefit which the legislation will confer on the citizens or a substantial body of them, and the interference with the personal rights of the citizens. Moreover, the presumption that every act of the legislature is constitutional until the contrary is clearly established applies with particular force to this type of legislation." They were dealing with that legislation in that jurisdiction. In short, Mr. President, all rights, even the constitutional rights, are not absolute, but may be restricted where required by the common good or the need to protect society. And if I go back to where I started, from 1972, from that quote in the public opinion, right through to where we are, I do not believe that control orders that seeks to take Jamaicans from amongst the unattached, from amongst the pool that potentially can find themselves into gangs, but putting them under some control. You're not locking them up, but you're asking them to comply with certain strictures, including providing training, serious social intervention that they must comply with, cannot be one that anyone would find to be oppressive to the individual, but it also stands great good to our society. And we are here as legislators, Mr. President, to take the appropriate steps to protect society, to protect Jamaica. Today's vote, I support the amendments as just one more step in that journey. Much more is needed, Mr. President. With those comments, I support this bill and I thank the members. Thank you, Mr. President.
Senator Samuda, you wanted to say something?
President, I would like to move for the suspension of the debate to allow for its completion at next sitting.
Will you please, members, allow me to make the decision as the President as to whether I'm going to put the question? Members would have heard the question ably put. Senator Hill, you need to come down a bit more then. Members would have heard the question so ably put by Minister Samuda, that the debate on the bill entitled An Act to Amend the Criminal Justice Suppression Criminal Organization Act be suspended for a date to be fixed. Those in favor? Against? Ayes have it. The question now, Mr. Acting Leader, is for you to determine, is there any other business to be dealt with today?
Mr. President, given that we have no additional business for today, and indeed we did get through some amount of business since morning, I'm going to ask that we close the session for today for a day to be announced. Thank you.
Thank you very much. Members, the question is that the Senate be adjourned for a date to be fixed. All in favor? Aye. Against? And just before I adjourn the Senate, please be advised that there is a new copy of the Standing Orders Committee, Standing Orders of the Senate, which incorporates recent decisions of the Standing Orders Committee, and that there, and that they are on the website of the Parliament. And just before we close as well, the Senate offers its condolences to the President General of the Bustamante Industrial Trade Union on the passing of George Fife. He's a long-standing member of staff of the Bustamante Industrial Trade Union, someone who I had the great pleasure and privilege of serving with in another capacity somewhere else. So I ask that the Senate record its condolences and to write to his family indicating that we have observed his passing. Senator Gale, I'm not going to ask you to speak on him because the tongue of good report has already been heard on his behalf in many quarters. But the Senate, and certainly Senator Brown on a normal condition, would have said something. But I ask that we just record our condolences to the family of Mr. George Fife and the larger family of the Bustamante Industrial Trade Union, the larger family of the unions in general, and of course the working class movement of Jamaica. This Honorable Senate now stands adjourned.
This is we're committed to reducing the impact of disasters occurring in Jamaica. We're ever ready to assist you before, during, and after a disaster. But everybody have a role to play, so make we work together and follow the plan. Whether rich or poor or where you come from, hurricanes affect everyone, so be prepared. Prevention is better than cure. Be prepared. Listen to ADPEM.
A message from the Office of Disaster Preparedness and Emergency Management.
Oh.